morning, everybody. This is Lea Stokes with Vesta Property Services. I'm the Vice President for our Northern Operations. We'd like to welcome you all this morning to our end of year board certification class for all you new board members or proposed board members out there, or just committee members that might want to attend. We are fortunate to partner up this morning with Ed Ronsman of McCabe Ronsman. Ed and I have been doing this for, I think, around, 15 years, something like that.
Yep.
And we really enjoy the education process of what we offer, not only to our clients, but to other associations around the state. So McCabe Ronsman is a firm that specializes in condominium and homeowner association law. And obviously this class is registered with the division, and so you will get a nice little certificate to prove that you know everything you need to know about COAs and HOAs and the statutes and all of those good things as we come to an end. So without further ado, Ed, I'm going to turn this over to you and let you take it from here.
All right. Well, thanks, Lee. Thanks, everyone, for joining in on a Friday morning. I know we're in budget season and annual meeting season, which is kind of a double whammy for Lee and for our managers. So I appreciate everyone joining in. If you're a new board member, welcome. I know that some of you are board members that have attended previously. And hopefully, if you have a question, please feel free to ask it for anybody, or that you pick up something new. So this is a state-approved course. So if you have been elected and it's within 90 days, you're to take this course and you get a certificate. It covers you for up to a year until you're elected. So if you're a committee member or somebody that was thinking about running, maybe you have an annual meeting in the spring and you take this right now and you are elected or appointed to your board, this will satisfy the requirements too. So I'm going to share my screen here. All right. So I am able to make a copy of this available upon request. I know we're also recording this. If you do have a question, I would request that you type it out in the Q&A button here on the Zoom link. That will make it easier for me to see. That way I can make sure I'm answering questions and I can mark them as answered versus anything on the chat. So let me see, going to the next slide here. So if you can take this information down too, this is Brittany in my office. If you email her, she will get you a certificate from today. I'll also have her email at the end, and I will type it in the chat box here too. So that way you can see in case once we move past this slide, if you missed it. All right. All right, so we're going to be talking about kind of four main topic areas, which is the operations, elections, financial reporting, and budgets and reserves, and then official records, maintenance and access. I also have at the end, I'll go through it a lot more quickly than what I would normally do, where we'd kind of be able to discuss it further. I do have some of the legislative updates that were passed this year, and we taught a previous legislative update course with Vesta previously. But I do have some of those at the end of it, just so you have it, and I'll mention them briefly. And that way, if you want to have a copy of the PowerPoint too, I'll have it down there. But so we'll be talking about that as well and how it kind of fits in with all these different items. The objectives are we want to increase your knowledge of your duties and obligations and the applicable Florida statutes. We want to define the role of the board. What are the obligations, the legal obligations as a board member, protecting your association, and then you want to identify any association problems and issues. Hopefully, if you take one new idea away, especially if you're a repeat board member that you've been on the board before, I think we'll have a successful day today. I know this is going to be a lot of information, especially for new board members, but I hope you take a lot out of it, because we're going to really be covering pretty much the gamut of what you could be facing as a board member for your community association. All right, so operations. The other thing too is that when I'm going to go back on here, so we have like these four main topic areas. Operations, when you see, we're going to be going through this takes up probably the first half of the presentation. The elections, the financial side, the official records, and the legal update is more in the second half. So if you see that we're going long, that's kind of the way it is. But just wanted you to be aware of that. All right, so let's talk about your governing documents. Your community association governing documents typically include, basically these items in descending order of authority. So I have these listed as the highest priority document is your declaration. That could be your declaration of condominium, your declaration of covenants and restrictions, your CC&Rs, whatever you want to call that. If you're a condominium or if you're in an HOA, that is the highest priority document that you're going to have. Then from there, you have your articles of incorporation. That establishes your association as a corporation, typically not for profit. You may have a for-profit in here, but probably all corporations not for profit. And it establishes you as a corporation with the state. So you can actually go and find your association as a listed business. It's going to be a nonprofit, but you can find yourself on the State Division of Corporations website. Then from there, you have your bylaws. Your bylaws kind of work in tandem with your articles of incorporation. The bylaws typically include the composition of the board, the election of the board, the terms of the directors, more of the operation of the corporation itself, rather than containing what I call use restrictions, or what can you do with your property. Your bylaws typically don't set out your rules and regulations, your covenants, your any easements there may be. That's all really going to be set forth in your declaration. Then you have your rules and regulations. You can also include in here your architectural guidelines. These are typically documents that kind of follow from, that can be adopted by the board or by membership potentially through one of these higher priority documents. So a lot of times your declaration may have kind of big picture type stuff regarding what you can do with your property, but it may say, for example, that the association through the board is responsible for administering and maintaining the common area. Well, from there, then you might adopt your rules and say, well, we have the ability to control the common area. Here are some of our rules. You can't fish in the ponds. Here are the pool rules. All that stuff that typically falls in your rules and regulations. More of the details, the day-to-day that maybe can change from time to time, and that's typically done by board vote. That's usually contained in your rules and regulations. So the biggest thing that you need to note from the governing documents here is that you cannot change a lower priority governing document that would conflict with a higher priority governing document. So for example, what happens a lot of times is that the higher the priority of the document, usually the more membership input is needed in order to change that. So a declaration change oftentimes might need 2/3 or 3/4 of the members' approval, versus a bylaw change or a rule change might only need a board vote. And so there's a tendency to say, well, maybe we could fit this in a bylaw change or a rule change and have a board vote. The problem is if you do that, and if it conflicts with the higher priority document, that change is not going to apply. You're still going to default to what the higher priority document is. And then you can create inconsistencies. Maybe a previous board did it, then the subsequent board is looking at it and say, well, our rules say this, but it conflicts with our declaration. That's when problems can arise there. So you want to make sure that your documents are in tandem, that the decision-making flows from it, and that you're adopting your rules subject to powers that are granted within the declaration. That's another thing too, is that the rules and regulations and your architectural guidelines, if you're in an HOA, in order to adopt those, you typically have to have the authority set forth in one of these other documents. Now, 90 to 95% of the time that is the case, but you'd be surprised at some communities where it says that rulemaking authority only applies to common areas, but there's no rulemaking authority, for example, for what you can do with your unit or with your parcel, in which case then you might need to amend that declaration or the bylaw or the article provision about rulemaking authority to expand it beyond not only the common areas or the common elements, but also for the property. So where I'm going with this is that the rules and regulations, when you're adopting those, it's not a statutory right. You have to actually have authority in your governing documents to establish those. So you want to make sure whenever we're contacted as a law firm to say, hey, we've adopted some of these rules, can you take a look at them? What we'll first look at is and say, do you have the authority to adopt this rule in the first place? And then if that's the case, then we look into the wording of it. Is it reasonable? That kind of thing. So just something to look out for when you're looking at your documents, and just knowing what your authority is to adopt some of these rules in your architectural guidelines, for example. The other thing I want to mention too, in terms of the governing laws, while we're here kind of at the start, is if you're in a condominium association, you're probably aware, but you're subject to Chapter 718 of the Florida statutes. That's the Condominium Act. For HOAs, it's Chapter 720. It's the Homeowners Association Act. Then you have other statutes for timeshares, for mobile homes and cooperatives. So there's a lot of property-specific statutes that you have. Probably 80 to 90% of what you can do with your community, if you're addressing a statute, is going to be contained in those property-specific statutes. However, there are also statutes that do come into play sometimes. Typically, the second most common one, so you have let's say if you're in a condominium, you're always going to look to Chapter 718 first. But if there's a gap there, if there's something that's not covered by it, then you're going to look to the corporation statute that governs your community, which for almost all of you in here, it's probably going to be corporation not-for-profit statute. So that's Chapter 617 of the Florida statutes. Have to take a look at that. That typically governs corporations, operations, powers of the corporation. If a lot of times your articles or your bylaws say that the association shall have the powers of a corporation not-for-profit, in which case then you would look at that and there's a whole list of things that a corporation not-for-profit can do. That's a lot of times where we have to reference that. And then beyond that, there's lots of different statutes that have one-off issues that can affect your community. And the ones that I like to bring up, there's a separate statute outside of the corporation, outside of the condo one or the HOA statute or any of the property specific ones that governs towing, for example. That's under Chapter 715 of the Florida statutes. Then you have a different statute that governs renewable energy devices. So that comes into play if, like, there's a big lawsuit up here in St. Augustine regarding clotheslines, and that was found to be a renewable energy device. Well, there's a statute that governs that. Or you're dealing with federal regulations regarding satellite dishes, that sort of thing. So there's all different types of laws that might impact your community, but the main one that you're going to be looking at are your property specific ones, and then the corporation not-for-profit or the corporation for-profit statute. Some of the things the association must do: you must establish a budget. You want to set aside funds for future maintenance, collect assessments to pay for your common expenses, and then enforce your rules and regulations. So the biggest thing that we like to talk about regarding, obviously your budget's going to be your framework. We're in budget season right now. That helps make sure that you know, okay, what are our expenses for the year? And we're going to talk about that in more detail later, but we need to know to operate. We need to know what are our expenses, what are all the things that we're responsible for, and then how are we going to pay for it? So that's establishing your budget. The good thing is that you're not reinventing the wheel whenever you establish your budget each year. You're going to take a look at your previous year's budget, take a look at your funding levels. Do you have increased, if your contracts, are they going up? Did you go out to bid? All that stuff. You might be tweaking the funding levels, but by and large, you're going to be using the really solid framework from your previous year's budget. Obviously, adding in things that have come up that you should have been or did not include before. And then how you're going to fund that. So that's kind of those first three bullet points. The enforcing the rules and regulations is something I like to spend just a little bit of time on. We talked about that before, that your declaration contains your covenants and restrictions, your use restrictions, what can we do with our property? And then you have your following rules and regulations from there. And especially for older communities, ones that maybe were developed and have changed over time, like most communities do, where maybe certain rules, the current board and the current type of membership just doesn't feel like it fits their community. The question is, what do we do with this? And the answer is, well, if you have it in place, you should be looking to enforce it. However, if you do not feel that it fits your community, you should look to amend your documents to remove that as a restriction or as any type of governing what type of activity can take place. If you don't do that and you have it in place and you don't enforce it, the problem that you have is that if there's ever a violation of that same rule by a different owner in the future and you haven't enforced it previously, you might be prevented, even if it's a valid restriction that's in your covenants. It's a selective enforcement affirmative defense. That's probably the number one defense that's raised in any type of an enforcement action, which is, yeah, I know this is contained in there that we're not allowed to do this, but you haven't enforced it against everybody, and now you're starting to do it again. So you're selectively enforcing against me. So that's the big issue with not enforcing what's in your covenants in terms of enforcing your rules and regulations, that it's difficult for an owner to sue the association and the board for not enforcing its documents. That's a difficult lawsuit to bring. And there's some cases on this that have basically said that it's really within the board's discretion how to enforce and when to enforce the covenants. But there are ramifications that come with that if you choose not to, and then you start picking it up, that there may be defenses on the other side. But while that's still a difficult, action to bring by an owner, you have those in place for a reason, that you should be looking to amend them to take them out. The other thing, though, too, is that just because somebody complains about a violation doesn't mean that it actually is one that the board feels like it's a violation of the covenant. So somebody may say, hey, my next door neighbor's property looks really bad. I think you should send them a violation letter. And maybe that neighbor has a very particular, nitpicky sense of what landscaping should look like. And the board looks at it and says, No. Is it perfect? No. But is it something that we consider to be a violation of our documents? No. So we're not going to take action on it. Just because you receive a complaint doesn't mean that you as the board have to take everything and then all of a sudden, send a violation letter out. That's within the decision making of the board. It's called the business judgment rule, where the board, as long as it's acting reasonably and reviewing its covenants, and a court is not going to second guess most times what decision a board makes, unless it's so far outside of what a reasonable person would, or it goes beyond the boundaries of what a reasonable action would be. The board is going to defer, or the court, excuse me, is going to defer to what the board does. So again, you as a board have the ability to determine whether or not you consider a violation to exist. Now, if there is a blatant violation and you don't take one from an owner because you don't consider it to be one and you're wrong, of course, then that can set up selective enforcement arguments again in the future, or waiver arguments, whatever the case may be. But I like to bring that up because you will find owners, especially if you're in a condominium association in here, you get owners that complain about noise violations, but when you're only hearing from that one owner, but none of the other neighbors are complaining about it, that might be a subjective complaint or a neighbor to neighbor argument that they're trying to drag the association in. That's where the association, again, has the ability to fact find and determine whether or not it is going to take any action on it. Owners don't like hearing when the association is not going to move forward with a violation. I like to let those owners know, if they're continuing to be vocal, to say, hey, this is not something that the board feels like is a violation. However, you have the ability to contact your neighbor and enforce the governing documents if you feel like it. There's a case that says that owners can utilize the covenants in an action against another owner. It's just that the complaining parties usually want the association to do it because they don't want to pay their own attorney, and they think the association should be the one that always has to bring these type of violation letters when it could be more subjective in nature. So I know that's a lot of time on that one point, but it's a bunch of issues that come up. And I think you're going to see that if you're a new board member, if you haven't served on a board before, that it's ultimately going to come down to your decision making. You're going to have recommendations from your manager, and you're going to receive reports, whether anonymous complaints or complaints from owners putting their name to it, but it's still up to the board to decide how to move forward with it. Some of the responsibilities of the board and what to know: you want to protect and ensure the interests of the association at large. Avoid personal gains, and you need to act fairly and equally. So remember, you're really, what you're doing is you're protecting the assets of the association, including the homeowner's value in their homes. So that's part of it. Now, if you take a look at it, one easy way to look at it is you have 100 homes in your community and they're each worth $300,000. That's a $30 million asset if I'm doing the math right. Okay. That's what you're looking at in terms of you're preserving the property values. And you always see it in the news. You see it online of people complaining about condos and HOAs. And maybe it's because it's in the industry. It's the only area of law that I practice in, that I've represented associations for 13 years now. Is condo associations and homeowner associations can work very well, and they can help the members and the community and preserve property values if it's done right. Okay. We've all seen in the news. I always like to joke about Seinfeld with how they portray condo boards. And I like to say, yes, I do have some clients that operate that way. But by and large, when you have a fair and reasonable board that's operating, and you have reasonable restrictions that are uniformly applied to everyone, that is the kind of, for lack of a better term, the secret sauce that can help your community work well together and work in harmony with your homeowners and the renters that are in there. While also preserving your property values and making sure that it's a good place to live, that's not overly burdensome, but is a place that you buy into a community to have these restrictions in place to make sure that you're maintaining property values, maintain access control and that sort of thing. So that's why you really need to protect and ensure the interests of the association at large through uniform enforcement, keeping up with your documents, amending them as necessary, and so on. Obviously, avoiding personal gains, that's a big one. That's a big no-no. In terms of getting on the board, you're serving as volunteers, but you cannot come on the board for the desire to have a personal gain for any type of a personal interest that you may have in a vendor or a business relationship that may be involved with the association. Obviously, just receiving kickbacks as board members is a big no-no. So that's a huge thing, of course. You need to act fairly and equally. I've kind of talked about that, where you want to show that you're treating everybody similarly. The biggest thing that I can see with communities where there are problems is where there's an argument that you're picking on me, but you're giving unfair treatment, or more favorable treatment to your neighbor that has the same type of problem that I do, for example. So acting fairly and equally is going to go a long way to show that you're being fair, whether or not maybe members may agree with every single decision that the board makes, but if they can show that you're acting, the same to everybody else and you're acting reasonably, they can at least respect the decision that the board has made, even if they don't agree with it. Maintain your common area interests, of course. That part of what you have is you have existing amenities, common areas, and so on that you want to maintain those, keep those. That helps keep the property values up. You'd be surprised that I've seen some boards that have come in an effort to try to, keep the assessments lower. Also then, kind of sacrifice maybe the common area maintenance, keeping up amenities, making sure they're fixed properly. You want to make sure that that's being done. That's part of why you buy into a community, is so that you have these common areas and these amenities that are being maintained to a level that you would expect, that they're usable, and then again, help to maintain the property values. And that kind of goes along with promoting rather than diminishing all the common area interests. So kind of like including this slide, we're in hurricane season right now, but it looks like we're at the point where hopefully we don't get a really late storm, that we've made it through a season without any type of a major event. At least we're operating from Northeast Florida, but statewide here, we didn't really have a huge event, catastrophic event really like we've had in previous years, which is good. And so once we get through this and you're looking at your policy, if they're coming up for renewal, talk with your insurance broker to talk about making sure that you're properly protected. And so looking out on the left-hand side here, 5 insurance clauses or issues that you need to be aware of. You want to have law and ordinance to policy limits. That means that if there is an insurable event that requires work, that you receive money to bring it up. Let's say you're an older community, especially that maybe the building code was different when your community, your clubhouse was built or your buildings were built, that you have a law and ordinance to policy limits, so that if the code has changed and now you need to have a firewall, for example, that wasn't required before, that you have that included so you can get the money. Otherwise, if you don't have law and ordinance to policy limits, what's going to happen is you're going to get the money to bring it up to what the code was previously, not to what it is now. So that's why you want to make sure you have law and ordinance to policy limits. You need to have a wind-driven rain endorsement for any type of a storm event. Most policies probably are going to have that, but just make sure and check with your broker on it. Want to have proper coverage of all structures, including the signs, light posts, dog houses, and all that. Make sure everything is scheduled. Don't skimp out on anything that's covered, so that if there is damage to it later, you want to make sure that it's covered as part of an event. A co-insurance penalty, what happens there is you're underreporting how you're insuring the property. If you have $1 million structure, but you're reported and you're insuring it as an $800,000 structure, if there is an actual storm or casualty event where, especially from like a reconstruction standpoint, you're going to have a 20% co-insurance penalty. That's the difference between what it was actually worth versus what you insured it at. So you're not going to get enough money then to actually bring it back to where it is if it's a reconstruction or a repair job. And so obviously the amount that you save on the premium for having a little bit lower of a structure is going to be far outweighed by what you could be recovering if you had properly reported it in the event of an insurable event. So make sure you're properly valuing everything when you're going out for your policy renewal. And then you want to have replacement costs and everything. You actually have to have that for condominiums. Replacement cost means the cost it would actually take to put on a new roof, for example, and not, well, yes, you need a new roof, but after depreciation, we're going to cut off 30% because you need to replace your roof in the next couple of years anyways, or whatever the case may be. So replacement cost is what does it actually cost to replace this, as opposed to actual cash value, which is the amount to replace it less depreciation. So you want to have replacement costs and everything. So underneath this, you need to bring insurance claims within 2 years. That was a change as of July of this year. Previously it was 3 years to bring a claim. Typically now for flood events, that's different. That's a much tighter time frame. I believe it's either 60 or 90 days. So you want to make sure though, for any type of like a wind-driven rain, like a hail event, a hurricane event, something like that, that's not a flood event, that you need to bring those claims within 2 years. The reason why I think they cracked down on the time limit is that any claims that were brought more than 2 years after what would be a casualty event tended to be more of the more tenuous claims, that whether or not they're fraudulent or just, not the strongest of claims, they're trying to crack down on it to make you file that quicker. And that hopefully should reduce some of these more frivolous claims that are brought. Obviously, though, that means that you have to stay on top of it and make sure that, hey, if we have damage, we need to get somebody out here to be able to tie it back to this insurable event and make sure we get our claim filed on time. Then the right-hand side, if you're in a new community or if you're in a community that's had a big reconstruction project, whether it's a balcony replacement, roof replacement, whatever it may be, you can bring a claim for construction defects against the responsible parties. The statute of limitations is 4 years, typically from when you knew or should have known of an issue, but most of the defects are what are called latent defects, which means that you may not see it on the surface, but that you've got a problem behind the surface. The most common thing that we saw was all the stucco litigation. You might see a couple cracks here and there that you can caulk and you can paint over, but what you don't know is that those cracks are resulting in water that got behind there and you've got wood rot behind it. So you might not see that wood rot and you might think that you covered the issue just by painting it. But so whether or not that causes a 4-year period to run, that's an issue of fact. But in no instance can you bring a construction defect claim later than 10 years. That's called the statute of ultimate repose. And the 10 years runs from different triggering events. If you're in a new community, the safest way to look at it is that you need to bring within 10 years of when the certificate of occupancy was issued. For a reconstruction project or roof replacement, what you're really looking at is from the completion of the contract, and you have 10 years from the completion of the contract. So there's different triggering events. If you are in a new community, or if you're in a townhome or a condominium, or even if you're in a single family, a homeowners association that has, roads that the association owns and clubhouses and amenities that may have issues, you really want to take a look at this time period to make sure you don't prevent yourself from bringing a claim against the responsible party. That's the biggest thing that we let clients know, that they don't realize that a lot of these things aren't a maintenance issue. It's an underlying construction problem that you can bring claims for on behalf of your association, on behalf of your members, and you have a much better ability to bring that claim as an association rather than individual owners trying to bring claims. So talk with it. If you've worked with our firm, we've looked at this at no cost for our clients just to look at the available time periods. You just don't want to let that time period go by. So again, construction defects and insurance clauses, I wanted to make sure that we cover that for your communities. So board responsibilities, you want to act as one unit to set policy, enforce your governing documents. We talked about enforcing your rules and regulations before. That really covers that bullet point. Maintaining the value of the property, we've talked about that. Conducting board and annual meetings. Obviously, you need to have meetings in front of the membership as the board to set your policy. The annual meeting typically is where your election takes place. We'll talk about that a little bit later. And you want to set goals for your association. What do you hope to accomplish this year? And that's one thing that I kind of talk about practically is set goals for yourself, but be reasonable with your goals. Don't try to get too much accomplished, because if you try to set, hey, for this year, we're going to accomplish these 10 things. And if there's 10 major projects, we're going to have a brand new landscaping done in the community. We're going to do our roof replacement. We're going to do upgrade our amenity center. All that stuff. What can happen is if you put too much on your plate, you're not going to devote the appropriate time to all of the individual tasks. Then if you focus on, okay, for this year, let's focus on these 3 big ticket items. I think we can get that done and we can do it and put our best effort forward on it. That's where I say setting goals for your association. Some associations have almost a strategic planning session. You don't have to do that, but it's a good way to maybe start the year and say, hey, what do we hope to accomplish this year? How do we do that? Do we need to set committees and all that? That might be a good meeting that you have, whether it's now, if you've just been elected to your board, or going into the first part of your year. I think it'd be something good to do. And then you need to maintain the association's financial stability. We'll talk about the budgeting with the operations and the reserve side. So these are some of your responsibilities as the board. All right, so what are your legal responsibilities? You actually have a fiduciary obligation to act on behalf of your membership. And what a fiduciary duty is, it's the duty to act for someone else's benefit and to act in the best interests of the association and its members. So it's actually the highest duty afforded by common law in terms of acting as a fiduciary. So you're required to act in somebody else's best interests. You have to act with good faith, diligence, care, and skill. This is the big thing, is the duty of loyalty. Duty of ordinary and reasonable care is what I usually like to focus on. And then a duty of confidentiality, both during and after your term of service. What that really means is you want to make sure that if you have anything that's privileged that you talked about with your attorney, if there's any legal issue that comes up, you have a duty to keep that confidential, to not waive that attorney-client privilege, for example. But really, going in for most of you thinking about this, okay, what have I got myself into serving as a board member, right? I'm volunteering. I'm not getting paid for this. Am I able to be sued? This is one of the questions that I usually receive is, can I be sued as a board member? And my answer is, the first part is yes, but here, and this is it's a big but, which is that just because you can be sued doesn't mean you can be successfully sued. All right. So in order to be successfully sued, you have to show that you're acting outside of any type of ordinary and reasonable care. So if as long as you're operating within the advice of the professionals that you've worked with, whether it's your CAM, your CPA, your attorney, any your insurance agent, as long as you're taking the advice of the professional that you've worked with, even if that decision goes wrong, that doesn't mean that you breach your obligation, your fiduciary duty to your board members. It's when boards act outside of that advice and get the association into trouble that you can argue that, hey, you did not take the advice. That's not what a reasonable person would do. That's when the board can get in trouble. But just because some member doesn't like the decision that the board makes, even if they disagree with it, doesn't mean that you're going to be sued as a board member. That being said, going back to the insurance portion, you're looking at all the different insurance policies that you have in place. Obviously, whether or not you insure your common areas, your buildings, if that's required. But obviously, your biggest thing, the number one thing I would want is your D&O policy, your directors and officers liability policy that will protect you as an individual board member and as the board as a whole. If there's an action that's brought that would trigger anything under that policy where, and it's usually for, hey, this board failed to do this or they did this wrong, so I'm going to sue the association. That's when your D&O policy typically kicks in. And you want to make sure that you have obviously good coverage for that so that you provide defense costs. That's the number one thing. The board may be 100% right, and you have owners, though, that file lawsuits out there all the time. You don't want to have to pay the money just to be proven right at the end and then try to collect your legal fees potentially from an owner that might not have the ability to pay those. Having insurance in place, make sure that you can have coverage or insurance defense counsel, appointed for you where their fees are paid by your insurance carrier. So make sure you have good D&O policy in place so that even if you're not successfully sued, you don't want to have to pay that money out as an association in the meantime and then have ability, a hard time collecting that later on if you're found to be right. So that's the biggest thing from your legal responsibilities. Again, acting as duty of ordinary and reasonable care. That's the biggest thing that I like to highlight from this. All right, so some practical things I like to talk about too. Building community. You want to become community involved. You want to seek a positive resolution to community and membership issues. You've seen it all the time. Maybe the reason why you ran for the board is because you may have attended board meetings and had a bad interaction with a previous board member. And it's easy for tempers to flare, especially when there's disagreements. But remember that you're all in a community together. If it's a residential community, you're all neighbors, whether you're living there, or if you're renting out your property, but it's a community that tempers can run high. You want to try to seek a positive resolution to community membership issues, emphasize reasonable living and respect, kind of going along with that. Respect ideas, even if you disagree with them, respect where they're coming from. Showing, I think the biggest thing when I've attended board meetings is as long as the board is fairly listening to people and not being judgmental, or you have people all the time that might comment and come out of left field and think that they know what they're talking about and the board disagrees. But even the way that the board responds to that can go a long way. If you're dismissive of it, even if somebody thought that they were coming in well-intentioned with the disagreement, if you're dismissive of something, that can lead to distrust or conflict among the members and the board, where then they look for ways to find the ways for the board to screw up, for example, or to find ways to come after you later, and they're going to be looking over your shoulder even more than what they normally would be. So you want to seek a positive resolution to any type of member disputes. Create healthy relationships with renters. This is a big thing. I think there's kind of a stigma attached with renters that they don't care as much about your community as the homeowners do because they don't actually own the property. But listen to them, invite them to attend board meetings if there's an issue that comes up that's going to affect everybody in the community. Whether or not you don't have to allow renters in, but I think that by offering to allow them into a meeting to make them feel part of the community, I think that goes a long way. And really what happens too is when you have a good relationship with renters, we talk about this later in terms of from a collection standpoint, if the landlord, the owner stops paying their assessments, you want to have a good relationship with that renter to let them know, hey, we have the right to collect your rent to offset the assessments. We're sorry we have to do this, and we encourage you to talk to your landlord. But having that healthy relationship with renters, I think will help, if that situation comes up. Another thing that I've really recommended, and I've talked to my associations that I represent, is creating some type of a welcome package for renters, whether it's, hey, here's a copy of our governing documents, here's our website. If you have any questions, please let us know. Make them feel part of the community, invite them to social events that we have more, when COVID allows even more, open activities that we've had previously. So, and then finally, you want to establish committees. This is important because you as a board, you're making all the big policy decisions, and obviously you're working with management. I'll talk about that in just a second here, but establishing committees to really help make your decisions as a board. Lean on the people that have expertise in your community that want to help out, but maybe can't run for the board, but would like to, focus their help on a specific issue that they may have expertise in, whether it's a retired CPA helping with the financial committee for the budget, a recommended budget, for example. Or maybe a lot of times I see it, retired attorneys or an attorney in your community that if you're looking to do a document rewrite that they may look through and help make suggestions to then forward on to legal counsel. That's usually where I see, attorneys come into play. Anybody that's served on a board before and they don't want to serve now, but they're in a leadership position that they can help out with any other type of committee. Or I usually find, law enforcement or, kind of related to that, law enforcement adjacent, they typically like to help out with access control, for example. So find those people to help. The good thing about committees is they're doing a lot of the legwork for you as the board, but it's still the board's decision to go along with their committee's recommendation. Usually committees do not have the ability to bind the association. What their job is, hey, we're going to look into this. We're going to come back to you with recommendations, and it's then up to you as a board. And if you, respected those people enough to appoint them to that committee, then you can feel good about what you're getting from them so you can make a good decision based upon the data that you have. So really look into establishing committees. The most successful communities that I represent tend to have a lot of committees in place to help with decision-making for the board. I think it also helps with your board meetings so that if you have a lot of this legwork done and you have committee reports and you can have a decision being made, that can keep your board meeting times down, as opposed to the board where it feels like it's not only setting out policy, but then also trying to talk through and figure out and go back and forth on the decision making for it. I think it can help with your meetings be more efficient and streamlined too. All right, so some of the responsibilities. The board is responsible to make decisions and to set policy. The board should reach a consensus on policy and direction. So I like to say the board is the big picture of the policy decisions. Then you have your manager, that's what you hired to really carry out the board directives and the policies. The management works with the president to fulfill the policy of the board. That's typically the president's role, is to act as a liaison with management to help carry out the policy of the board. Where I find that there can be conflict between board and management, or the board and the president, whatever the case may be, is the board getting too much in the day-to-day details and the nitty-gritty, as opposed to, hey, we set forth the policy, we've hired you as the manager, we've elected you as our president. Let's make sure that that policy is carried out. If there's any issues that come up, let's bring it up at the next board meeting. But when the board tries to get involved in every single decision that's being made, that's when there can be conflict. And again, I always speak on behalf of management, on behalf of Vesta. This wasn't Lee or anybody else at Vesta that's asked me to say this, but I've just experienced it enough to say that the biggest complaint that I hear from managers directly is, I wish that my client would just let me do my job. This is my profession. It's not just a job that I have temporarily. I have a license for this. I have continuing education requirements for it. This is what you've hired me to do. You need to trust me to be able to do it. Doesn't mean that management, is perfect in any means, but, have management reports, look over it if there's any questions, but you need to trust the management company that you've hired to carry out that policy on behalf of the board. So communication with management, you want to have a shared vision between the board and the community manager. Board and management should agree on expectations. You want to understand the difference between setting policy and directing operations. I just talked about that for a bit. Having action lists and monthly reports, I think, go a long way to help kind of have some continuity with your meetings and seeing the progress on projects and so on. Mutual respect, to underline this, again, I kind of brought it up already, but respect the fact that your manager, that they're in this industry and that they attend continuing education events, whether it's for their credits that they need for their license, whether it's through industry trade show and expos and education events, all that kind of stuff is to help better educate them to then work on your behalf for your community. So respect the fact that the time that your managers put in for you and what you've hired them for. And then support your manager. It's a thankless position. They're kind of on the front line, as I kind of put that in there for the board and the officers. understand that a lot of this, and I've seen this a lot, there's a lot of burnout for your managers. And that it can take a toll receiving all these angry phone calls from homeowners and kind of being that line of defense a lot of times for maybe the policy that the board had. They could be the right policy, that you still are going to have people that disagree with it. You're going to have angry homeowners that then take out their frustrations on management. And there's a lot that goes into it. I know that sometimes, you can look at, and I see this, that communities that switch from management companies, that the grass isn't always greener. And you have to understand that working with your manager, that it's a thankless position a lot of times, and it all goes into the mutual respect and understanding what goes into that. So again, I like to highlight that almost like from a mental health standpoint, to kind of understand what your managers go through, and you as board members too, that you go through that as well. And I think there's obviously, that's why there needs to be mutual respect. And I'm preaching to the choir here because I don't have your membership in here, but your members need to understand kind of the work that goes into being a board member and as a manager, and that it's a thankless position a lot of the times. Board member roles and responsibilities. Your homeowners, or typically your homeowners, you're elected to serve by the peers. You're responsible for the conduct of business and delivery of service to the association. You're subject to the governing documents and applicable laws. We've talked about that. You're trustees on behalf of others, and you provide oversight and guidance to the associations. We've talked about a lot of this. What are the qualities of a good board member? A strong board member has good character, strong integrity, calm judgment, a willingness to serve, is committed to the best interests of the community as a whole, has relevant experience or background, typically serving on a board or some type of a volunteer, organization, something like that, has previous volunteer service, has strong people skills, and is a servant leader. Servant leader is somebody that is humble, that doesn't have a personal agenda, is thoughtful in their approach, is respectful, willing to give their time, and does what's in the best interest of the community. That's what a servant leader is, kind of coined by Robert Greenleaf, I have here, that worked for AT&T, and describing what an ideal management style is. Characteristics of a weak board member. Again, when cumulatively, this is what you typically find, is that they're unable to put the welfare of the community first. They work behind the board to run things his or her way. They're impulsive or quick-tempered. They have a personal or hidden agenda. They put individual interests first. They have little or no experience in management, leadership, or service, and they're unable to work with others for the common good. So kind of, even if you don't have little experience, that doesn't mean that you're a bad board member. It's just that that's usually combined with some of these other characteristics to find what we find to be a weak board member that isn't doing their community a good service. All right, some of the roles and responsibilities of the president. It's the day-to-day officer. They call the meeting to order. They announce the agenda and adhere to it. They recognize members entitled to the floor, stating a question, calling a vote, announcing outcomes. So helping really keep the meeting on track. That's the biggest thing from a presidential standpoint. Maintain order through impartial parliamentary procedure. They're familiar with all the rules and documents of the association, and they appoint committees per the bylaws. It depends on what your bylaws provide. The other thing too is that you might want to have, whether or not you need to amend your bylaws or your articles, or maybe adopt a resolution, is giving the president, authority maybe to authorize one-time expenditures up to a certain dollar amount, or working with management to authorize it. That may be something to look at to further entrust your president so that they can carry out certain day-to-day powers without needing to go back to the board for a vote and having to call a meeting on it. Vice president serves in the absence of the president, all the same powers and responsibilities when they do fill in for the president there. The secretary is a recording officer, the custodian of records, although typically that's assigned over to the management when you hire management. They keep accurate minutes of all their meetings, and they sign the minutes and other governing documents, again, or any other documents, but typically a lot of this is done by management. Same thing with treasurer. They keep a thorough and accurate financial records. They produce regular reports of disbursement and income. They produce annual financial reports to the membership, and they submit financial records for audits, and they authorize the disbursement of funds. But again, largely accomplished by management when you hire management. And then you have the manager. Scope of duties is specified by the contractual agreement. Take a look at the contract that you have with the management company. They carry out the policies set forth by the board. They administer the services, programs, and operations of the association. They provide information, training, and leadership. Vesta is a great example of this, with all of the number of classes that we teach and are scheduled for your community at no cost to you. Act in the best interest of the association. That's what the manager is required to do. They have a statute that governs what their obligation is to their association that they manage. And they keep the board informed of the progress of key projects, of course. All right, so you have your annual meeting. That's typically where your election takes place. You have a review of the year, and that's where the budget is presented, depending on the time of year. So it depends on what your governing documents require and the time of year that you have. If you're having your annual meeting now and you've adopted your budget, typically you might have an overview, or if you have it in the spring, it might say, hey, here's how we were financially last year. Here's our budget that we've adopted for this year. That's typically all done. It's, part of a town hall form or an update for your membership. Then you have your board meetings. The frequencies defined in your documents might say that you have to meet at least so many times per year, but usually then you can call a special meeting of the board as long as you have at least 48 hours notice, depending on what your governing documents may require. But you want to make sure you're meeting frequently. I would say most communities, but it's hard to get by without meeting at least quarterly, is what I typically find for community associations. Then you can have special membership meetings. So an annual meeting is a membership meeting. That's determined, so if you're going to have the meeting, you have to have a quorum of the members, as opposed to a board meeting, which is a quorum of the directors. But you can also have special membership meetings through the year. Maybe you have your annual meeting in November, but in March or April, you might want to have a meeting to amend your governing documents, for example. That can be a special membership meeting. And the notice that's required and the quorum that's required, it's going to be set forth in your governing documents. And then you have committee meetings. This is kind of a big difference between condos and HOAs. For condos, any committee that you have, the meeting has to be noticed in the same manner as a board of directors meeting. For HOAs, the two type of committee meetings that you have to have are any type of committee that makes architectural decisions on behalf of the association, and then any committee that can disperse association funds. Or if there is a committee that has the ability, some type of a budget or that they can utilize that the board's already approved, that meeting would need to be noticed to the membership. The safest way, of course, is to notice all of your committee meetings as an HOA, just like a board meeting, and have it open so that if there's a decision or something, you don't want to have something later on that might be criticized as being, well, you didn't give appropriate notice. So if you have a question on that, talk with management, talk with legal counsel. But that is a big difference between condo and HOA committee meetings. So meeting requirements, you have to have a quorum. It's required for official business, and any interaction contributing to the development of ideas constitutes a meeting. This is a big one that comes up. So if you have at least, if you have a 5-member board, and if 3 of the board members are in one place discussing association business, that's arguably a meeting that should be noticed to the members. That's the biggest thing that comes up and a question that we get. But probably, so I know it can be difficult. Like if everybody's at Publix at the same time or something like that. Doesn't mean that, hey, well, here's a third person coming up, I need to walk away. Try to limit your discussion so that if it is association business, that you have it, at a board meeting so that the membership can witness that discussion. Certainly don't want to meet outside of a board meeting where there's a quorum and make decisions. That's a big no-no. That's a big thing that, you have to make decisions at an open board meeting. But the biggest thing that I see where communities think, well, we're going to have a workshop meeting, for example, budget workshop. A workshop, if you have a quorum of the board there, that's still a meeting. It's an interaction contributing to the development of ideas that constitute a meeting. So you can have that workshop meeting, but it needs to be noticed to the members, and the members should be able to attend. Even if you're not going to make a decision at that meeting, you would still need to notice it. Now, if you have 2 out of the 5 board members there, that is not a quorum of the board. Therefore, it doesn't need to be a notice meeting. So that's the difference. If you have a majority of the board members that constitute a quorum versus if you don't, that's where you might need to notice it to the members. So again, the frequency is determined by the governing documents. You have to provide proper notice. There are certain notice requirements depending on the type of meeting that you're having. If you're having a budget meeting for condos, for example, and I talk about that later, but it's a 14-day notice requirement with a copy of the budget. HOAs doesn't have that 14-day notice requirement in the statute, maybe in your documents, but you may only have to provide 48 hours notice and just put on the notice that, hey, we're going to be considering assessments in our budget at this meeting. If you're passing a special assessment, or if you're passing a rule regarding what somebody can do with their unit or their parcel, that's a 14-day notice as opposed to a 48-hour notice. So depending on the type of meeting that you have, you need to make sure that you're giving appropriate notice for it. And then the last point on this is that you might have somebody in the audience that thinks they're smart and say you're not operating in the sunshine, and the government in the sunshine, mandates that you do this. You can actually reply. It says the Florida government in the sunshine does not apply to associations. You're not a governmental or administrative agency. your statutes that you do have that govern your community are similar in a lot of ways, but it's not the same as the government in the sunshine. So quorum requirements for condos: for a membership meeting, it's a majority of the voting interest. For a board meeting, it's a majority of the board members. A quorum is not required for an election, for example, if at least 20% of the eligible voters cast a ballot to have a valid election. So maybe you don't have a majority of the members to establish a quorum for your annual meeting for the condo. You can still have your election if at least 20% of the members cast a ballot. And then suspended voting rights don't count towards the quorum requirements. We talked about this a little bit as part of like collection discussions and strategies, but one of the things you're able to do is if a member is 90 days delinquent in the payment of a monetary obligation, that you can suspend their voting rights. For condos, I believe it's 90 days, plus they also have to be $1,000 delinquent. But what you can do is you can vote to suspend their voting rights. You have to give them appropriate notice before that suspension goes into effect. But what it does is, let's say you have 10 out of your 100 members that aren't eligible to vote. That reduces your eligible voting interest to 90, from 100 down to 90, which then means that your quorum is based upon 90, or if you have an amendment, for example, and it's a percentage of that 90 rather than of the 100. So that's why it is important. And we found this to be the case, especially when we had the housing crisis and we had a lot of delinquent owners and if associations were trying to vote on items, that we encourage them to go through and properly suspend voting rights to make sure that it'd be easier to kind of exclude out the people that weren't participating, they weren't paying their assessments, that it makes it easier to make a quorum and have a vote. So make sure, if you have that you're utilizing it. The biggest thing too that I would say is those voting rights only become effective when you vote on it at a meeting, when you're suspending that. Just having a policy that says once you hit this, that's not going to be enough. You actually have to vote on it at a board meeting for those individuals whose voting rights you're suspending. And then you have to give them written notice of the meeting where that suspension took place. So just make sure you're properly following it, but it can be a helpful tool to make sure that you're making your quorum or that you can have a proper vote. For HOAs, this is a big difference. For member meetings, that the statute says that a quorum is 30% of the voting interest unless a lower amount is provided in the bylaws. So even if we have some communities that their bylaws state that in order to make a quorum for a member meeting for HOAs, for example, for your annual meeting, that you need a majority of the voting interest. The opinion that we've given is that no, the statute overrides this and that it can't be more than 30% that's required to hit your quorum. And then you could amend it to go below the 30% amount. Whereas for condos, it can be a majority of the voting interest. I think the reason why you see 30% for HOAs is that you have a lot of master associations that might have thousands of members, whereas it's really uncommon to have a condo association that large. And so I think they found the need to have a lower threshold for a quorum, for example, for a member meeting for HOAs. Just like for condos, it consists of majority of the number of directors for a board meeting. Decisions that require a vote of the members must be made by a majority vote at a meeting where a quorum is obtained, unless a different number is provided for in the governing documents. And then again, suspended voting rights do not count. Board meeting attendance is open to all owners. Anytime a quorum is present, owners have the right to attend. And these are the two ways that you can have what's called a closed meeting. If legal counsel is present for the purposes of providing legal advice regarding pending or possible litigation, meeting notice is still required. But you have to say, hey, we're having a meeting. It's going to be a closed meeting, but you still have to let the members know that you're doing that. The other type of meetings you have in closed session is a personnel meeting where personnel matters are being addressed. There hasn't been a lot of case law on this as to what's considered a personnel matter. What I typically state is if there's like whether it's an HR issue, potentially a medical issue, or something involving personnel, I think that's where it's okay to have a closed meeting. But where I wouldn't go so far is that some communities have said, hey, we're going to interview new management companies. We're going to have that in closed session. I've typically said that's not a personnel matter that you can do in closed meeting. I think that needs to be open to the membership. So and the biggest thing is you want to be careful that if you have a closed meeting when you shouldn't have, and if there's a decision made there, somebody could invalidate it later if they find that meeting should have been open to the membership. So consult with legal counsel if you're thinking about having a closed meeting, if you're not sure about it. That way you get an opinion on it. And we as a law firm or any law firm that you work with can tell you, hey, no, I think it needs to be noticed, open to the membership, because there can be some ramifications for it. For condos and HOAs, you have the ability to participate via video conferencing, as long as it's in real time. So Zoom, Teams, Skype, FaceTime, whatever it is, as long as you're there in real time, and of course, telephone, and you're deemed to be present for the purposes of a quorum and for any type of vote that takes place. All right, so board meetings and emails. This is a big thing that comes up. Both of the condo and the HOA statutes have been amended to say that you can use email as a means of communication, but that you cannot cast a vote on an association matter via email. So if it requires board approval, you cannot vote on it by email. You need to have a notice board meeting where you vote on it in front of the membership. What they're saying is you're allowed to use email, yes, but you can't use it as a way to vote on anything. And I would even discourage, going so far as that you're kind of talking it through so that the only thing left is the vote. Because what you're doing now is you're excluding the membership from participating in that meeting, seeing how the board is making its decisions. If you're doing it behind closed doors, so that by the time you show up to the meeting that you've already discussed it and approved something, that's where there can be distrust from the members that the board is operating behind closed doors. The other thing too is just note that any email that you send as a board member is potentially open for inspection by the members, or even if you can shield that as part of an official record inspection request, that it's going to be open as part of any type of discovery that goes on. So just know that anything you send by email can be discoverable later on. I always recommend that you set up an email address that you only use for association matters. That way, if you have anything that comes up, you can kind of just turn that email address over, or if you get off the board, you can turn that email address and the login information to the person, that's taking that position. I think that's always helpful. Certainly, just speaking or I've seen board members get in trouble where they use their business email, and then if they are involved in litigation and now their corporation, their employer that they work for is now being subpoenaed for records, that doesn't look good for you as a board member. So don't use your work email address whenever possible. All right, so planning board meetings, you want to define the purpose. You need to create an agenda, which includes the date, time, and location, a review of the minutes, the treasurer's report, any committee reports that you have, any action items, and then any new business to be considered. And then invite the appropriate people if you need to ask questions and get some advice in real time from people that you work with, whether it's your CPA, your attorney, your landscaper, any contractor that you've hired for certain work. Invite the appropriate people to your meeting. All right, so some meeting hints. You want to start on time, stick to your agenda. Robert's Rules of Order, I put that here, but really just follow like a uniform kind of parliamentary procedure so that you're being consistent and uniform with everyone. That really goes a long way. The key components are you need to have a motion, a resolution for anything that comes up, any debate on it, and then the vote that takes place. That's to be the big thing for your meetings, of course. I talk a little bit about owner participation at meetings in just a second. So your minutes, this is an important document that's maintained by the association. I talk about that in a little bit more, but for condos, your minutes are maintained in perpetuity. For HOAs, it's for up to 7 years. This is going to be the record of the basis of the action taken by the board. It's an official record of, hey, I may not have attended, I didn't witness the discussion, but if I were to go back 5 years, I can look and see what decision the board made, what happened, what was on the agenda for that meeting. So it's really important to make your minutes accurate and reflect what happened at the meeting. What I recommend as part of the contents, going on to the next part here, what you're really doing is you're taking your agenda for the meeting and then cutting and pasting it and then putting underneath each agenda item what action or what happened as for each of those agenda items. What you don't want to see, and what I always recommend against, is don't let your minutes become a transcript of the meeting. That's where you can run into issues where some offhand comment that's thrown in may come back to bite the association later on. It can lead to a lot of issues. And I always think about this from the purposes of litigation, where if the association's maintaining one position, but somebody can argue, well, look what your minutes say. It looks like one board member brought this up that's different from what you've stated, or a member brought this up and the board didn't act on it, or whatever the case may be. I always like to say the minutes should only include the agenda items and what action was taken. So if there's a motion made, it was seconded, there was debate on the issue, and then here was the result of the vote. That's all you need to have. If you have a member or even a board member that says, I demand that the minutes reflect that I brought this issue up and the board didn't act on it, or they disregarded, or they ignored me, you're not required to include that as a board. That person is able to record the board meeting themselves, and I have that on the next slide here. So the biggest thing is members are not able to dictate what's included. It's up to a board vote to how to adopt the minutes. But members are not entitled to have that to become a transcript, nor would I recommend that you have that become a transcript anyways, for the reasons I just stated. All right, so owner participation and personality problems. Owners may speak on any designated agenda item. You can adopt reasonable rules when that takes place. Some associations say that their member forum is at the beginning of the meeting or at the end of the meeting. I like to recommend that members be able to comment on agenda items when they come up and just be consistent with that. That allows for them to talk about the item that they're concerned most about at the time when it's being brought up. But you can adopt rules regarding this. I would recommend, and again, the rules should be voted on at a board meeting where it's included as a business item. And then you have a separate resolution or set of rules that you have that you can then point back and say, hey, we adopted these at this meeting. It's reflected in the minutes. Here's where they are. The membership can have a copy upon request. And rather than making it up during the meeting itself, that's where you can run into problems for members. Members are entitled to heard regarding matters the board intends to consider. So it's only on agenda items, though. If a member is trying to talk about something that's not on the agenda, you can cut them off and say, hey, it seems like you're talking about something that's not on the agenda. If you'd like, you can email the manager or however you choose to handle communications. And then the board can consider whether or not to include it on the agenda for the next meeting. But members are only able to comment on agenda items. You can add emergency items as they come up, but just really use that sparingly. Don't consider everything to be an emergency item because you maybe forgot to include it on the agenda. Just be cautious with that. Again, meetings can be recorded. You can also adopt rules regarding that. Typically, you might want to address, meeting rules, which include the ability to comment, how long you're able to comment. Typically, it's up to 3 minutes on an agenda item. And then you may also include, if you'd like to tape record the meeting, you're able to do so. Some rules that I've seen as you need to place the tape recording device where people can see it and you don't move it, that you don't move it around. If you're going to video record the meeting, members are able to do that, but I would even recommend there that you require advance notice before the meeting so that the association can choose whether or not it also wants to video record the meeting. So you can adopt those as reasonable rules too. All right, so talking about finding and suspension of use rights. So I want to kind of provide an overview of this. This goes into, you have your governing documents. We talked about that before. We talked about that you have the obligation generally to enforce your governing documents. If there is a violation, you should enforce it, because if you don't, and there's another violation in the future, you may be prevented from doing that. So you go forward, you handle the violation process, you send a letter. What is the next step then if people do not comply based upon that demand that you send out? The board then is able to impose a fine. There's statutory limits. It's up to $100 per day, not to exceed $1,000 in the aggregate. For HOAs, you can actually go above the daily amount. So you can go above $100 a day. You could go above $1,000 in the aggregate, as long as your governing documents are properly amended to allow that. So I would get with legal counsel to effectuate a proper amendment for that. So you impose the fine, but that fine is not able to be collected until it's at least approved. It has to be approved by a committee made up of, can't be board members, can't be officers, it can't be spouses of board members or officers or employees. So that committee has the final say. If that committee disagrees with the board, then the fine is not able to be collected, and you have no further action you can take, at least as to the fine. Now, if the board disagrees with the committee and still finds it to be a violation, then you still have the ability to go forward and enforce the violation. The biggest thing that I can say about fining is not your only tool for enforcement. So some communities say, Ed, I can't get anybody to serve on this fining committee, so does that mean I can't enforce our documents? No, that's not the answer at all. Fining is just one of the tools that you have. And it's a way that if it's set up properly, it can help resolve a lot of issues without having to go to legal counsel. But if you don't have a fining committee, management sends out a couple of demand letters, they're ignored. The next step typically is then to send it over to legal counsel. What we do is we can send a violation letter, we can send a demand to either go to arbitration or to pre-suit mediation. And then there's the next steps to there, that if we still don't have compliance and we don't reach an agreement, then we can get an order on it, whether it's from an arbitrator or from the court, that can be enforceable. And so there are ways to enforce it. It's just that it can be more expensive if you have to get to legal counsel, because obviously you're paying us. And while our attorney's fees can be recovered as a prevailing party, you might not get everything paid. Judges a lot of times tend to sympathize with owners, even if they do have to pay attorney's fees. They might cut, an award by 10% or whatever the case may be. But even then, you're paying your attorney to get that far. You still have the ability to enforce your governing documents. But what I would really strongly recommend is, if you're on your board and you ran because you're not sure that the enforcement process is being properly handled, take a look at what your documents provide, look at whether or not you need to adopt a resolution further clarifying your finding process, making members aware. I've worked with communities where we've drafted like a finding and enforcement resolution that more kind of fills in the gaps between what your documents provide and what the statute provides. And that way you have a more uniform process. So really consider doing that. But I should say too that the finding committee, they meet after the board imposes the fine. You have to give at least 14-day notice of the hearing in front of that committee. There's some debate as to whether or not you have to request that hearing. I always recommend that you just schedule it at least 14 days in advance and show up, even if the person never responds, so that if they decide to show up, at the last minute, that you have your committee there and that you can have the hearing. Once the fine is imposed, it's due within 5 days of providing notice of the hearing results. One practical consideration is the board imposes the fine versus the delegation of the finding authority. Some communities I work with where I go with on this is, Ed, do we have to have a board meeting and vote to impose a fine every time there's a violation where we want to impose it? Or can we delegate that authority to our CAM or to our president? And my response is it hasn't been tested yet. I think if you do delegate that authority, that you do need to make a motion at a meeting to say, hey, in lieu of the board imposing the fine, I make a motion to delegate that authority to our president and have that seconded and it's voted on. Then that president can work with management and say, all right, you've sent out the appropriate notices. Yes, I approve that a fine be imposed as of the date that the letter goes out, still subject to approval by the committee. The risk associated with that is that a court or an arbitrator may find that the board cannot delegate that finding authority, that there should have been a board meeting. So you're kind of trading off the flexibility of not having to have a board meeting every time with the risk that the fine may not be upheld. So that's where there's kind of a risk tolerance level with the association. All right, so, and we talked about considering adopting the resolution, establishing when the fines begin. So this is a thing that the statute doesn't provide. It just says that a fine may be imposed up to $100 a day, up to $1,000 in the aggregate. But it doesn't say, well, does that mean when the committee approves it? Does it mean when the board approves it and they vote on it at a meeting and it runs from that date forward? Or can it be from a notice and that by the time the board gets it, they can say, hey, you were told before that you could be fined. You've still been in violation for the last 10 days. So we're imposing the $1,000 fine on you. The statute isn't very clear on that. So I think that if a board would adopt a resolution to further clarify it, that helps make sure that the board is being uniform and it sets the expectations for the violating party that this is the process that you're going to follow. And I have here, it's better to have the procedures in advance rather than reacting to the situation and making up the rules as you go. All right, so that's what we have for operations. I see that we have some questions here. If you're in the chat, if you have any questions in the chat, if you can run them over to the Q&A part, that will help make sure that I can help address it and answer it. So Mark asked, what are the personal risks or liabilities of a board member should someone file a lawsuit? Again, we talked about that a bit, which was if a board member is found to have breached their fiduciary duty, there is a potential that they can be personally liable. It's very hard for that to be proven and for that to be successful, but you want to make sure you have your D&O policy in place to defend you on it. That's the biggest thing that you may have. But the biggest thing is to avoid any type of personal responsibility, of course, is to act fairly, equitably, and reasonably as a reasonable person would. If you do that, even if a decision that you make didn't turn out to be the best one, you shouldn't be held personally liable as a board member. Another question is, when someone applies to live in the community, what criteria may be legally be used to accept or decline? I think this is going into approval powers. Be very careful, even if you have that authority in your declaration, that what you may think is a proper reason to deny may be found to be discriminatory. And there's obviously the Fair Housing Act that applies. So I'd be very careful as to determine what is legally acceptable. I would talk with legal counsel if you're thinking about denying the right of somebody to either own or to rent in your community. Let's see. There's one question, owners asking about the possibility of incorporating a small 1970s era well-maintained condo community, necessary equipment location for electronic vehicle charging stations, how associations are addressing this item. It's a good question, and I actually have this as part of our legislative updates. It's coming up more because it's the legislature's made it easier for electric vehicle charging stations to come in. Usually though, it's the owner that's requesting it, and they have to kind of jump through all the hoops to show that they are going to protect the association, that they have plans set out for it. So I would say that it's probably a more emerging industry in terms of maybe consultants that can help associations kind of modernize if they want to implement electric vehicle charging stations. But it's a newer thing. What we have found though is that owners are able to request them. And even if it might otherwise be a material alteration from a condo side that might require membership approval, there's an exception now as long as the owner has jumped through all the hoops to protect the association, cover the cost of it, make sure it's done properly. So that way you're not held up by a member vote, but it's otherwise, properly approved. So it's a good question. It's something that is emerging though. So we'll kind of see as it goes along. George wants to know, what can we do about ponds and driveways for more than one day? It's not in our covenants. Can we add this? Yeah, I think that would be something you want to look at as part of your parking provisions and what your declaration may provide. Does it allow you to maybe adopt a rule on it that flows within your declaration that doesn't conflict? You just need to look at your governing documents and whether or not you need a member vote or if that can be done by board vote. But that certainly is something you can cover. Again, it comes down to whether or not it's a member versus a board vote. Vincent asks, what do you do when the president and the treasurer cut down dunes for $3,800 without a board vote or approval? So there's there's an email expressing concern for disregard of procedures. So that comes down to whether or not it should have required board approval versus can an individual officer exercise that authority. That's kind of very fact specific. That depends upon the documents in your community, and it kind of falls in the gray area of what requires a board vote versus an individual officer. I would probably want to take a look at what those officers' duties and powers are under your governing documents. And if it doesn't fit within it, you can argue that that was an improper action. That being said, if it's already done, it's hard to say what what you can do to enforce that, or what's actionable from there. What are you hoping to get out of it, aside from maybe an injunction prohibiting that type of activity in the future, for example. So it's a tough one. But I see that happen a lot where there's a disagreement between an individual officer doing something that may not have had board approval. George wants to know what constitutes a reserve fund for a not-for-profit corporation. I'll talk about that later, George. I think that'll be answered later on. Can we increase penalties from, I think it says 1 million to 5 million, and how do we do this? That would be a really high aggregate fine amount. It's $1,000. Maybe the M is, I might be misreading, I apologize. But $1,000 to $5,000, for example, you would typically need to, that should be done through a declaration amendment. I have to look at the statute again. I think it says that it needs to be updated in your declaration or your bylaws potentially. I would need to take a look at that, but that usually is going to require, I would usually recommend membership approval, just because anything that's done by member approval, even if it's a really high aggregate amount, now it goes beyond whether or not it's reasonable. A court usually errs on the side of, well, if the member voted for this, they're going to uphold that even more than what's done by a board vote, for example. There's a question about CDDs having the ability to amend a budget that was previously approved. That kind of goes beyond this. That goes under CDD governance, and we're not really covering that here. Typically, though, they have their budget season. I believe that they have the ability to adopt it, and then I believe though that they can't typically amend it. I'm not as familiar. I'm not a CDD attorney, so I can't state that. Different though for a condo or an HOA where you are able to amend your budget. There's a question of, we have a new management agreement that was not signed or agreed to. What can we do as a board about this? I would argue that if it's not signed or agreed to, whether or not you've kind of accepted the terms of it, if you operated, and if it does have a term on there, there may be agreement by action, whether or not it's explicitly signed. So I think you'd want to make sure that you get something that's signed that will help, the parties understand what their responsibilities are and what the term limits are and so on. Can the president be the treasurer at the same time? Typically, yes. Usually the only prohibition is that the president cannot also be the secretary, but it does depend on what your governing documents provides. Is there a statute requiring an attorney to be involved when amending the governing documents? There's a question of whether or not recording and preparing an amendment is the unauthorized practice of law. I think that's where you typically want to have an attorney assist you with it, whether it's trying to get your manager to amend it or as a board member. And usually, and not to pump us up, but this is as attorneys, we can usually provide guidance on the wording. that may come back that may be important later on. Words or commas even can mean a lot of things. So I would encourage you to work with your legal counsel, but there are some arguments as to whether or not, recording an amendment's the unauthorized practice of law, for example, or amending them and then sending them out for recording, for example, versus engaging legal counsel on it. I think there was one question about getting a PDF of the presentation. I have it in the chat. Look for Brittany's email. We can make sure to provide you with a copy. I'll provide a copy to Vesta too. So if you request it either through my firm or through Vesta, we'll make sure to get you a copy of it. See, we have a couple more questions, then I'm going to jump in, but I know these are related to operations, so I wanted to address these before I move these on. Does an attorney represent the board or individual board members or the HOA? This is a great question. As a law firm, we represent the association, but we take direction from the board of directors. We don't represent individual members of the board, nor do we represent the board as a kind of an institution, but we are taking our direction from the board as a governing body, if that makes sense. So sometimes members will say, you represent me individually, I'm a member of the association, and our response is no, we represent the corporation as a corporate entity, and we take direction from the board who you have elected as a membership. That's kind of our response that we typically provide on that. There's a comment here about a news source that likes to cover HOA disputes. What's the best way to handle media? Get your legal counsel involved. Typically, a lot of times a no comment is the best type of thing. I think there's a lot of things that like to be sensationalized regarding HOAs without understanding that there are restrictions and laws in place that reinforce the association's ability to take certain positions on things. So I would typically recommend that you forward that to legal counsel to help make sure that you don't want to put a position out there, especially if there's subsequent litigation, that there's a statement that could be used against the association. That's the biggest thing when talking with any type of a media outlet. There's a question, our HOA only has 3 board members. Does that mean we cannot speak to each other outside of an announced meeting? That's the hard part with it. If you are talking about it, if you are going to limit it, it's not practical to say that you're not going to talk to each other outside of a board meeting. I would just say, try to limit that discussion so that you're not talking through certain things that should be done in an open board meeting, so that by the time you get to the meeting, you've already hashed everything out. That's where members can feel like, well, how'd you know to select this vendor? How did you know to make this decision? Well, we already kind of worked it out. Members should be able to participate in that discussion, whether or not you have to answer to them, they at least should be able to comment on it and participate in that discussion. So again, I'm not saying that if you're in a 3-member board and you see another board member on the street that you need to walk away, and you can talk about association business of, hey, we've got a board meeting coming up next week. I think we should bring this issue up. I think we should get with management to make sure that they get this report for us so that we can address it for the meeting. Yeah, that sounds good. Send an email out and I'll chime in on it. That's an appropriate discussion. What I would say is, hey, I know we've got this landscape proposal coming up. What do you think about it? I don't really like this company. I heard bad things from my neighbor about it. Oh, I didn't know about it. Okay, well, we should probably go with a different one, right? And then, okay, yeah, I like other company. That's where you can get into problems so that by the time you get there, you make a motion to approve the other landscape company without the membership being able to participate in. How did you get to that decision? And Johnson, looks like we need more board members. Yeah, you might need to amend your governing documents, typically your bylaws or your articles, to increase the size of the board. I think that helps, though, just to get more perspective. And so that if one board member can't make it, it makes it easier to attend a meeting too. So having a 5 to 7 member board, that's typically what I find to be the best size, maybe a 5 or 7 member. 5 usually is the most common, is what I would say. Brian says setting goals is a great idea, but this year's budget was approved by last year's board. Where are the funds coming from? Great, it's a great point. And if you're setting goals, certainly as part of the budget making process, if you want to increase landscaping, or if you got a new bid, that you should accomplish that as part of your budgeting process for the upcoming year. So that is a good point for having that in conjunction with your budgeting, if you need to tweak anything to be in line with what your goals are. All right. So we're going to go into, we have those questions. I've gotten through those that were in the Q&A part. Going on to election. So a lot of you may have come through this, or maybe if you are coming up on an election, you're interested in running for the board, or if you're just attending this in your elections in the spring, for example. I go through and I spend more time on the condo side, and that's because the condo election process, it's uniform for all condominiums. And I have recommended that HOAs adopt, whether it's the condo form or similar to it, because HOAs, as you'll find, are much more document specific. So I always ask that even if you're in an HOA to kind of pay attention to the condo side, to see what this is what I typically recommend. And I know a lot of other law firms do. So the regular election must occur on the date of the annual meeting or as stated in the bylaws, typically done at the annual meeting. Any vacancy on the board shall be filled by electing a new board member, and the election must be conducted by secret ballot. So there's a requirement for condos for secret ballots. Provisions may be made in the bylaws for board member term limits. If the term limits are not defined in the bylaws, then the terms expire on the election of successors. So what that means is if your documents just say that there's an election that's held annually and there's 5 members on the board, by default, it's a 1-year term. Otherwise, your bylaws can provide that you serve for 2-year terms if they're staggered terms and so on. A candidate must be eligible to serve on the board at the time of the deadline for submitting the notice of intent to run, which is 40 days before the election. It used to be that you had to be eligible at the time of the election, so you could have an ineligible candidate get their name in, get on the ballot. And I've seen this a couple of times where they were elected, and then then the board said, yeah, we had to include them on the ballot, but now that they've been elected, they're not eligible to serve on the board, so now there's a vacancy. And that's the difficulty. So now you look at it at the time that you're eligible, that you serve, that you put your name in to run for the board, that gets you on the ballot or not. Then going on the time limits, the term limits that you have. Directors in a condo may now have longer than a 2-year term. That was a change as of a couple of years ago. It used to be that you had to have 1-year terms unless your bylaws provide for 2-year staggered terms. Now you can have a 3-year term, 3-year staggered terms, whatever the case may be, as long as your bylaws provide for it. You cannot serve more than 8 consecutive years on the board unless you obtain at least 2/3 of the votes cast in an election, or even if you're going on past your 8th year as this is only for condos, by the way, it's only for condos. Or if you're if you have a 5-member board and there's only, 5 candidates for 5 vacancies, then you can serve even if you're going on past your 8th year. The other thing too was, when does the 8 years run? Because this was changed in the statute. And what the legislature came out with this year was the time period to calculate the 8 consecutive years began on July of 2018. So we're really not running into this issue until 2026. And so we received some clarification on that, whether or not it was retroactive, so that for, I think when the statute was adopted in 2017 and then amended in 2018, the question was, well, what if they've served from 2010 onward? Does that mean now they have to drop off the board now that the statute's been implemented? And they've come out and say, no, it runs from 8 consecutive years beginning in July of 2018. Again, not the case for HOAs. You could serve on your board for 20 years if you wanted to in a row, unless your bylaws or your governing documents prohibit it, but nothing in the statute that prohibits it. All right, so for condominiums, the first notice of election must be mailed or delivered no less than 30 days prior to the election. Candidates must submit their information sheets no less than 35 days prior to the election. So we had first notice goes out 60 days. You have 40 days to submit your, I had that from a couple slides ago, 40 days to get your name in. Then you have another 5 days after that to get your candidate information sheet in. And then from there, after so from 34 days to 14 days is when the second notice goes out, between that time period. And that includes the agenda, the ballot, if there is going to be an election because you have more candidates than there are vacancies, and then any candidate information sheets that are involved. So you can see that it's a very structured process. There are arbitration decisions where an owner, submitted their name on the 39th day prior to. I even saw one where I think they faxed it into the management, and the fax went through at like 12:15 a.m. on the morning of the 39th day. So they're only 15, 16 minutes late, or whatever. The arbitrator said, no, you have to have this hard and fast rule. Otherwise, how do you establish what that buffer period is? So it's nice because it's a very uniform process, and there's no reason really there's no decision-making like subjectivity that goes with it. So if you miss the time period, you got to point back and say, hey, this is what the statute requires. That's why I like recommending this for HOAs that might have loose election procedures. So going in for HOAs, the regular election must be held on the date of the annual meeting or as stated in the bylaws, must be conducted in accordance with the governing documents. Electors must be elected by a plurality of the votes. That means if you have 3 spots, you can't use 3 votes for one person. There's no cumulative voting, I should say that. And then plurality of the votes, that just means that it doesn't mean you have to have a majority of the vote of the membership to be elected. It's just the highest vote getters. This is the same for condos, and I included for HOAs, but it applies for both, that any person that's delinquent more than 90 days or has been convicted of a felony and has not had their civil rights restored for at least 5 years is not eligible to serve on the board. Members may nominate themselves as a candidate at a meeting where the election is to be held unless the governing documents provide a process for nominating in advance. So there's some confusion still for HOAs. The statutes have not prohibited nominations from the floor. What the statutes have said is that you can amend your governing documents to prohibit nominations from the floor as long as you have a process for nominating in advance. But if your documents are, and a lot of HOA documents are written this way, which say the election takes place at the annual meeting and there needs to be at least 14-day notice for the annual meeting. What that means is that there's no nomination in advance process. That means you have to allow nominations from the floor. And so you really can't even send out ballots there because you don't have a bylaw provision for getting your name in to get your name on a ballot that's mailed out to the members. That's where you can see if your community is like that and has election procedure like that, it is what the documents provide that's going to control rather than what your past policy has been. Even if a lot of communities have kind of said, well, in practice, we really are kind of like the condo side. It's just not what our bylaws provide, but we've already done this for 10 years in a row, whatever the case may be. There is an arbitration decision that says it doesn't matter what your policy or your practice has been. It depends. It's what's in your governing documents that's going to control. So it's very important to have, I would say, a more defined election process for an HOA. And if you don't have that, you should really recommend doing it, because I've seen most of the election disputes that I see that are brought up are from HOAs that are operating different from what their governing documents provide. So as of July of 2018, if an election is not required because there are fewer equal candidates and vacancies and nominations from the floor are not required, then write-in nominations are not permitted. And candidates commence service on the board of directors, regardless of whether a quorum was attained at the meeting. So the biggest thing is, in order to kind of forego having the election because you don't have more candidates than vacancies, you need to make sure you have your nominating in advance process, because then that also eliminates nominations from the floor. If you have to have nominations from the floor, then you have to still make your quorum in order to see, hey, do we have nominations from the floor? No. Okay, then we have these 3 people running for 3 spots. That's where most HOAs get into problems, is that they might only have 3 people interested, but because they still have to allow nominations from the floor, then they try and they can't make their quorum. And then guess what happens? Even those 3 people that were interested aren't placed on the board because they never had their quorum to have that election process take place. So the previous board members are what are called holdover directors, and that can throw off staggered terms. It's why it can be a real mess for your election process. So really take a look at it. Get with your legal counsel if you need to amend anything as part of your election process. Recalls, I'm just going to briefly talk about this. A recall is a way to remove a director before their term is up. It's the only way that you can be removed, which is by member vote. I've had this question before. Can we kick somebody off because they've missed 3 meetings in a row? My response has always been the only way you can remove a director is by a recall, which is by member vote or petition. You can remove that director as an officer if they've not been attending, and that can be done by board vote typically, almost always. But in terms of kicking them off the board, it needs to be done by recall. All right, so some of your proxy rules for condos. Your limited proxy must vote as specified on the proxy. Most things that are voted on as a condo have to be done by limited proxy. So whether it's an amendment to your documents, whether it's waiving or reducing reserves, if it's to waive the financial reporting requirements, all of those things that you're allowed to vote on as a member, the statute says that it must be by limited proxy. So there are very few things that become by a general proxy. When I talk about a general proxy, it's I can't be here. Here's my proxy holder. I'll let them vote however they want on any issue that comes up. For condos, you really can't do that too often on most substantive issues. You usually have to say, I can't be here. Here's my proxy holder, but I'm directing the vote yes or no on the following issues. And so that way it's your vote that is counted, not somebody that can kind of go around and gather proxies and now they all vote the same way on something. You're not allowed to use a proxy for election. That's done by secret ballot, like I said. And then the proxy is valid for 90 days from the date of the meeting for which the proxy was intended. But this is important too, so that if you can't make your quorum, but you're close, you can adjourn the meeting to a later date. And as long as within 90 days, you can actually use those old proxies to make sure that you make your quorum for the subsequent meeting. HOAs, there's a difference here. Directors may not vote by proxy at board meetings. Same thing for condos. You're not allowed to vote by proxy at board meetings. That's why, though, you're allowed to attend telephonically or in real-time video conferencing. Members have the right to vote by proxy as otherwise limited in your documents. But the big difference between condos and HOAs, nothing in the statute for HOAs prohibits voting in the election by proxy. And you can also use general proxy unless otherwise limited by your documents for anything that comes up in front of the membership. So big difference between condos and HOAs. Condos, typically any proxy that you use usually is going to be by limited proxy. For HOAs, there's allowance for that general proxy, which allows one person to hold 50 proxies potentially and vote the same way for all 50 owners. Whereas a limited proxy, you're going to have that variation as to how that owner votes on something. And then similarly, for proxies for condos as for HOAs, that the proxy is good for 90 days from the date at which the proxy was given. You can adjourn until a later date to go gather more proxies so that you can reconvene and then make your quorum and have whatever vote you need to have on it. All right, so that's what I have on the election process. Let's see. I don't think we have any questions. I don't see any questions on the election process, so no problem. We'll move on to the financial side here. All right, so what we're going to be talking about are your budgets, your operations, your reserves, and your accounting methods. You need to monitor your accounting records. Must be open for inspection. Accuracy is obviously critical. Establishing assessments through regular assessments and special assessments. Your regular assessments are going to be coming from your budget. Special assessments are not budgeted. That's where they come up as if there's an emergency item or an unanticipated expense. And then you have financial reporting requirements, which is, we'll talk about that too. So the budget, it allows the association to prepare for the upcoming year. The proposed budget it includes all the daily operational expenses and the estimated revenues. For condos, owners are entitled to 14 days written notice of the budget meeting unless the bylaws or the governing documents provide for longer notice. The meeting notice is supposed to be accompanied by a copy of the proposed budget. That's required by statute. For HOAs, the associations provide each member with a copy of the annual budget or a written notice that a copy is available upon request. Like I talked about, though, this is the big difference between the budgeting process for condos and HOAs. 14-day notice for one. For condos, not the same requirement for HOAs, but you still have to include on the notice for the budget meeting that assessments are going to be considered. So the annual budget, the governing documents set forth the responsibilities for preparing and implementing and funding the annual budget. And most budgets contain the administrative costs, maintenance, taxes, insurance, reserves. Really what you're looking at is anything that is considered to be a common expense that the association can treat as a common expense is going to be included in your annual budget to make sure that the association properly runs. You're going to have your management fees, any potential legal expenses. You have your landscape, any contracts that you have for ongoing service, whether it's for pool service, landscaping, anything else. You're going to have your insurance premiums, any utilities that you have. That's all going to be included as part of your operating budget. Big thing too, though, and this comes up from time to time is, well, can we budget for this? And well, is this a proper common expense for your community? Can you include, for example, as part of your operating budget, a line item for, future capital improvements, for example, whether that should be a reserve or an operating, but the main point is, can you budget for something that the association really can't assess its members for example? So you want to make sure, by and large, most things that come up, you can include as part of a common expense. There's usually language in your governing documents that pretty broadly defines what the board can consider to be a common expense, for example. But like an absurd example would be, hey, we're an Orlando HOA, and we are going to budget for the board members to get passes to Disney World, for example. I'm just giving you an extreme example. That is not a proper common expense that's regarding the operation of the association, right? Beyond that, that's for personal gains for the board members. It's not proper, but could an expense for maybe a board member, paying for a membership in some type of a educational organization to help them, educational opportunities, like one organization that I'm part of is called CAI. I've given the opinion, I think that's a proper common expense because it's for the education of board members, for example, rather than individual board members paying out of their own pocket. So you do want to be mindful of it, but there's usually pretty broad authority, just making sure you're being reasonable with it. You're not budgeting for things you're not allowed to either. So from an accounting standpoint, you have your cash versus accrual accounting. A cash basis, it's similar to a checkbook. What you're doing is you're recording income when it's deposited and expenses when they're paid. But the cash basis accounting method may not accurately reflect the association's true financial condition. It just shows the result of cash transactions, as opposed to accrual basis, where income is recorded when it's earned and expenses when they're incurred. Statements are more useful for comparing the results of the budget to the actual activity. And then the accrual basis, take into account timing differences. So an accrual basis accounting is typically going to provide a more accurate financial snapshot for your community. So you have a financial reporting requirement at the end of each year, and I like to kind of highlight what the requirement is here. The total, if you have your total annual revenues of less than 150,000, you just have to do a report of cash receipts and expenditures. If it's between 150 to 300,000, it's a compiled statement. From 300,000 to 500,000, it's a reviewed statement. And then if it's $500,000 or more in annual revenues, you have to have an audit done. Now, what you can do is you can have a vote to waive or reduce the financial reporting requirement, but it does require approval of a majority of the members at a meeting where a quorum is met, and it can only be done for that year. So there is an ability, and usually what that happens is it's from an association that would otherwise have to have an audit done each year. A lot of times they might vote to skip the audit every 2 years and maybe do it every 3 years, for example. That does require a vote, though, of the membership, and it has to be for each year. You can't say, we're going to vote to waive our audit requirement for the next 5 years. That's not allowed. In terms of what these statements are, a compiled statement, there's no audit or review. There's no opinion expressed. The CPA must have client and industry knowledge. A reviewed statement expresses a limited opinion that the statements are in conformity to the generally accepted accounting principles. You look at related party transactions, segregation of duties, cash and other key financial items, and you want to look at significant fluctuations. An audit is the highest form, right? It expresses an opinion that the financial statements present fairly the financial position and are prepared in accordance with GAAP. And then you want to look at internal controls and perform analytical tests. So funding the budgets, how do you fund the budget? It's assessments that are required from each owner. So what you're going to do is you're going to adopt your budget. And the first thing you do is, what are our expenses? What do we have to cover for each year? And typically then you back into that by saying, okay, if we've got $500,000 of expenses, we need to have $500,000 worth of income. How are we going to do that? You might have some surplus. You might have some smaller fees here and there if there's any type of a lease that you may have or other type of revenue. But by and large, it's going to be from your assessments that are going to then fund it. So then you look at your income from assessments and how many members that you have, and that determines obviously what the annual assessment is. The owner's property, whether it's their unit, their lot, their home, it serves as security for the payment of the assessments. I'll talk a little bit about from a collection standpoint in a little bit, but their property serves as security. Other sources of revenue, I talk about this, can come from rent, interest. I did see one community. I was representing a community that was wanting to pass. They wanted a fine for speeding restriction violations in a private gated community. And I spoke with the manager from an Illinois HOA, a really large Illinois, and they had a very well-defined kind of speeding process. And the manager said, oh yeah, it's great. We budget for it. It helps keep our assessments down because we know we're going to get $30,000 of speeding fines each year. So we just budget for it. And so you're kind of setting yourself up to become, these speed traps, right? If you do that. So I wouldn't recommend budgeting for fines, for example, but there are alternative, but really by and large, it's going to be from your assessment revenue. All right, so one question that we get is, hey, we were the previous board, whether it was the developer or just the previous board, tried to keep assessments low. Are we allowed to raise them over a certain percentage, or is there a statutory provision? The only thing is in the condos, if you go over 15% of the previous year's assessment amount, then the members can petition for an alternative budget to be voted on. But I've never seen that happen. That's the only thing from a statutory standpoint. It doesn't prohibit you from raising your assessments. It just means that it opens the door as a condo for members to propose an alternative budget. For HOAs, there's no statutory prohibition on this. Now, you do need to look at your governing documents, and some what I would consider to be poorly drafted documents by developers because they want to market it as, hey, here's what your starting assessment is, and it'll never go up more than 5% as an inducement for people to purchase in there. That really hamstrings the community because maybe that $40 amount or whatever it is should have been $60, and now you're already behind the 8 ball because you can never raise your assessments more. So but there is no statutory prohibition on raising assessments from one year to the next. So then collection of assessments, the manner for collection is stated in the bylaws or the declaration. For condos, it must be no less frequently than quarterly. For HOAs, there's no statutory provision on this. So a lot of communities I've worked with have an annual assessment or a twice annual or a quarterly or a monthly. But for condos, you have to have at least a quarterly assessment. And then you may be able to accelerate assessments for delinquencies. We've seen this with kind of repeat owners that keep getting behind in their assessments, that there may be a way for you to accelerate assessments when they become delinquent and require payment for the rest of the year. Just talk with your management and with your legal counsel so that you do that properly. Sure. So managing delinquencies, you want to establish a collection policy, what your enforcement procedures are. You need to apply it fairly and equitably to all owners. What I recommend is setting out, okay, here's the first notice that you get. Here's when the late fee and interest starts. And beyond this, once it reaches a certain date, this is when an intent to lien letter goes out. Here's when a claim of lien that can go out. I teach a 1-hour collection class just on collection strategies. But to kind of summarize it, just really for the purposes of this, slide here and what we just were talking about, I think it's really important to establish a collection policy for your association. It helps out your management, helps out your legal counsel that you work with if it has to go to the legal phase. It helps you as a board to not have to every time at a board meeting decide, okay, do we need to send the next letter? Or if you have a policy in place, you already know, hey, if an owner's 15 days late, they get this letter. If they're 30 days late, they get a late fee and interest charge. If they get to be 60 days late, then an intent to lien letter goes out. If the intent to lien letter expires, then we're going to record a claim of lien. All of that can be adopted by the board as part of a collection resolution. And then the board is not really tasked with any decision-making until it gets to a point of, hey, we've sent all these letters, we've recorded a claim of lien, we sent them a follow-up letter after that claim of lien. So they've received already probably 4 or more delinquency notices, and they're still delinquent. Now it's back to the board to decide where they want to move forward from it. That's what most collection policies that we've drafted for our clients have, that decision-making authority. It makes it more efficient for management to not have to wait for your next board meeting, for example. So establish that. It helps you then stay on top of your delinquencies too. What I found in 2008, representing communities that did not have policies in place, they weren't prepared for it, was they didn't know how to handle it. They were treating owners all differently, especially if maybe they knew a member, a board member knew somebody that was delinquent. And I had one community say, hey, we gave them over a year to try to come up with the money, and they just never were able to. And now we haven't gotten anything from them. Now we need to start handling collections. You're already so far behind the 8 ball on it because you're in many ways competing with the bank. You just want to move forward more quickly. It's easier to collect debt. That's fresher debt is easier to collect. Not that you're trying to kick people out of their homes, because you can foreclose on the property, but the more streamlined your process is, the more likely it is you're going to be uniform in applying it to everyone, and that you're going to reach a better resolution with people before it gets too far out of hand, before you then start with the collection process. So have that process in place. Then you have statutory remedies to enforce your collection rights. Amenity restrictions. You can suspend their use rights and amenities until the delinquency is satisfied. Again, talk with legal counsel about this, because there is a requirement in the statute that you vote and provide them with notice. It's not just like a standing policy that once you reach this time period that you're automatically cut off. You still have to vote to do that. But you can suspend amenity rights. I've seen, if you have the ability to, cut off their barcode or their key fob access or whatever the case may be. Talked about voting rights. And then we talked about application of rent, going after the renters, to require them to pay the rent directly to the association if the landlord's delinquent. I talked about that here. I'm not going to go over all this. It's part of the outline, but the bottom line is that you can demand that the renter pay the rent directly to the association. If they don't, they can be evicted. I typically don't recommend eviction as its own enforcement route, because what happens is you're evicting the tenant, but it doesn't get the association money at the end of the day. If the owner's delinquent, if the renter's not paying, I would recommend foreclosing on the association's lien, because that then gives you control. You actually take control and ownership of the unit, which also serves to evict the tenant out of there. But the teeth of being able to evict, and the tenant sees that, they don't want to be kicked out of their property before their lease is up. They don't want to have the hassle of moving. So there is obviously a penalty for renters for disregarding it too. So one thing is, whenever we're asked to proceed with collections against an owner, one of the things we always ask is, hey, is this property being rented? Because if so, we're going to send a letter to the renter right away, and that might resolve this pretty quickly. For condos, they're also, from a collection standpoint, you have the ability to enter into abandoned units. Now, what is considered to be abandoned? It's defined in the statute. It's dependent on whether or not they're in foreclosure or not. But the big takeaway from this is that you can enter abandoned units, turn on utilities, and then charge it back to them as an expense that can be lienable. Also, if there's an abandoned unit, you have the ability to appoint a receiver, get a court to appoint a receiver to lease the unit for the benefit of the association, which brings rental income to offset the costs and expenses incurred in unpaid assessments without having to go all the way forward to foreclose and then have a foreclosure sale and all that. So it's a quicker way. It's kind of in reaction to the housing crisis again from 2008 through whatever it was, 2011, 2012. So it came in after that, but if there is a downturn where we have more delinquencies with abandoned properties for condos, this is something we can utilize as a collection tool. All right, so what do you do with surplus funds? It's a good problem to have. It includes all the excess monies retained by the association after deducting expenses. If it's an association not for profit and the surplus is not from a special assessments, funds cannot be returned to owners. Excess funds can be credited towards the next year's budget or allocated to the reserve account. Special assessment surplus funds, it's upon completion of the specific purpose, the funds can be returned to owners or applied as a credit towards future assessments. Typically for any type of surplus, whether it's a special assessment or from operating side, usually what associations do is they find a way to throw it into their reserve accounts so that you don't operate it as a surplus to lower assessments artificially for 1 year. They want to try to keep the assessments the same, but maybe put more money to better fund the reserve accounts. That's typically what associations will do. But you do have the ability from a special assessment standpoint to reimburse those amounts. I usually don't recommend it. It's hard to do that because now are you paying the current owner? What if ownership changed between when the assessment was paid versus now when it's being refunded? That's kind of the difficulty with it. I think usually you find a better way to throw it into your reserves. The big thing though is that you can't take that special assessment surplus and then say, oh, hey, we got some money left over. Let's do this capital improvement project. If that's not something that's a proper expense of the association, you can't then utilize those funds for other than their intended purpose. You have to then either refund it or you can credit it for future assessments, which is typically through, I would argue, is by funding the reserve accounts more fully. That's typically what's done. All right, so an overview of reserves for condos. And I say this for condos, but it really applies for HOAs because a lot of the terms are the same that you'll see in here. It's just that the Condo Act, again, is more specific and there's the administrative code that covers this. But the purpose of reserves is for major repairs or replacements. I'll see some associations that have, some type of a deferred or a rainy day fund. The problem with it is that reserves are supposed to be used for an intended purpose. And usually when you have a reserve study done, you look at what are we reserving for? It's an actual physical component or structure that we have. And and we'll talk about how you calculate that. But when you have a rainy day fund, it doesn't really help you with, what is this meant for? I'm not saying you can't do it. It's just, it could be used for, if you don't specifically define it, it could be used for all intended purposes, especially when the board changes hands, for example. But you can only use reserves for their intended purpose. They have to be kept separate from the operating funds. For condos, you have required reserves, which are roof reserves, any pavement replacement or repaving, painting, and any other items for which the deferred maintenance expense or replacement cost exceeds $10,000. Those are the mandatory statutory reserves for condos. Your budget must include a fully funded reserve schedule. We'll get into how do you know if it's fully funded or not, but it does require fully funded reserves. Then you can have the pooling method versus the straight line method. The straight line method is what you're doing is you're taking all your reserve components and you're funding them each individually, and you can only use reserve items from that account for that purpose. The good thing is that you're making sure you're not pulling funds from one for the other. It makes sure that you're staying and only used for their intended purpose. The problem though, and where the flexibility is for the pooling side is, let's say you have, you don't need to replace your roof for another 5 years, whereas something came up where you need to repave sooner than you anticipated, and you don't have quite enough in your repaving, but you have enough in your roof. You can't take that money from the roof reserve unless you have a vote of the membership, as opposed to a pooled reserve, which is everything goes into one pot essentially. And as long as you're using it for a reserve item that's within that pooled reserve, you can do it even if you're using it sooner than what you expected. So it provides more flexibility. If you go from straight line to pooled reserves, though, you do need to take kind of a one-time membership vote, because what you're effectively doing is you're changing the way that reserves could otherwise be used, whereas before they were each for their own category. Now they're lumped in together. you have to have that vote for it. But most associations have been going to a pooled method for reserve funding. All right, for HOAs for reserves, the budget may include reserve accounts. If the reserve accounts are established, it's determined by a formula based upon the useful life, the remaining useful life, how much do you have to have each year for it. Needs to be maintained and funded and then waived upon a majority vote. I don't usually see members waiving reserve funds though. If reserve accounts are not established, there is a disclosure requirement, because what happens is if you don't have reserves and if there is a capital expenditure or major replacement or deferred maintenance, that it could result in a special assessment. And reserve accounts can be terminated by majority vote. There are basically three major reserves for HOAs. You either have developer reserves that were established by the developer, although now the statute just changed this year to say that if the developer established reserves, but they're otherwise not required in your governing documents, you are now not required to continue funding those developer reserves. Whereas before this year, you would have to have a member vote to terminate that. Now you can say, well, this developer established this one, but it's not in our documents. We don't have to do it. We're going to stop funding this moving forward. That's additional flexibility this year. The other two ways that you can have reserve accounts are by the governing documents authorizing the board to establish it, or if the members vote to establish the reserve account. Typically, though, the majority of the reserve accounts are either the developer established ones or through the governing documents that allows the board to establish them. All right, I talked about the funding methods, straight line versus the pooling. So Florida law provides that reserve funding should be included at the fully funded level. Owners may vote to waive or reduce the funding level, but the budget must contain the fully funded amount. So what was happening again, when we were in like the housing crisis and people weren't able to pay their assessments, as a way to help keep assessments lower, to make it more affordable, to encourage more people to pay, what some associations were doing is they were waiving the reserve funding. So they would say, hey, normally we would have to fund our reserves at $100,000 a year. We're only going to do it at $50,000 a year to save us $50,000, and that would help in our assessment amounts. In order to go from that $100,000 to $50,000 amount, though, you have to have majority approval at a meeting where a quorum is met. If you don't get that approval, by default, you have to have the fully funded reserve amounts. I've seen that happen before, where boards have kind of just established a lower funded amount without actually having the member vote. What you do then is at the budget meeting, if you have the budget meeting, you can adopt alternative budgets, subject to, if you have a less than fully funded reserve, saying, hey, I make a motion to adopt this budget with the less than fully funded reserves, subject to approval at a membership meeting. But if member approval is not provided, then the fully funded reserve budget shall go into effect. And that way you have the two budgets, and then you've got the motion that's passed, and then you have your member vote. If the member vote's not successful, then you've already made your motion to adopt the budget with the fully funded reserves. So that's what I would recommend doing from a procedural standpoint if you're thinking about waiving or reducing reserves. As part of that vote, there is information required as part of the notice requirement. You have to have like bold and in caps, and I think in font larger than anything else, basically saying that waiving or reducing reserves may result in an unanticipated special assessment. The idea being, hey, the reason for having fully funded reserves is that you have the money available when you have to do this project. By having less than full funding on it, you are not going to have enough money available, and so you might be specially assessed, which is a one-time charge as opposed to funding reserves as you go along. So there is a statutory requirement for that. So the reserve schedule, all the required deferred maintenance and the capital expenditure items it has to contain the estimate of the useful life, the remaining useful life, estimate of the costs, the funding balance at the beginning of every year, and then the required funding for the budget year. The best way to determine if you are like what that schedule should be is by having a reserve study done. It's not a requirement, but a reserve study is done by a reserve analyst who basically it's their job to do this, is what their industry is, to go out, look at your reserve items, what you're reserving for. They can tell you what the remaining useful life is, what the budgeting should be for it. And then you can then take that study and use it as part of your operating your reserve budget. And as long as the reserve analyst gives you fully funded reserves to make sure that you have enough money available when the time comes, then you can confidently use that and say, hey, this is what our reserve analyst said that we should do, so we have enough money on hand when the project comes up. That means that we're fully funded and we should be good to go. So again, other states, there is a requirement to have a reserve study done every so often. And honestly, because of what happened in Surfside down in South Florida, you may see this come into Florida where there may be a mandatory reserve study, which may include an engineer component, because reserve analysts are typically not engineers. They don't look at the structural components. that you may see this come as a result of the Surfside tragedy, with the idea being that you have somebody out there to tell you, hey, you have these structures that you're responsible for maintaining. This, this is the remaining useful life. And from an engineer side, they may require it for, buildings of a certain age to have not only kind of this, what I call the surface level reserve study, which is the roof, replacement and the painting and the repaving and stuff, but also a look at the structural components that a reserve analyst is not expected to understand. So this might come into play, but for now, it's not a statutory requirement, but it's a good practice to have a reserve study done. I put every 3 to 5 years. I really need to update this to say maybe every 2 to 4 years. It just depends on the type of community that you're in. All right, let's see if we have any questions on the financial side. There's a question from George. Can you form a reserve for replacement in a non-for-profit corporation? Yes, I think the question is, can you establish a reserve account for a replacement item that the association is maintaining if you're not for profit? Yes, that's the main purpose for a reserve account. Is that you have money on hand for that if there is a replacement needed later on, whether it's deferred maintenance or a replacement cost, that you have the money on hand that you've built up rather than having to specially assess your members for it. All right, so let's go into official records, maintenance and access. All right, so the official records of the association are open to inspection by any association member or their authorized representative. That hasn't been fully defined. The one question that comes up is, hey, if somebody says that they have an attorney, are they authorized to inspect the official records? I would usually state yes. And the main point is that it's open for inspection. There are certain records that you can keep back from members, and I'll talk about that, but otherwise it's for a member or their authorized representative. The records have to be maintained within the state. They need to be made available to owners within 5 working days of receiving a written request, sent to the board or their designee, which is typically management. The association is not responsible for the use or misuse of the information provided to a member or member's representative. This is important because what happens a lot is, like, sometimes an owner is trying to be a pain and they keep requesting records, or if you think that they're trying to pinpoint or have some issue with a neighbor, and the board will say, well, we don't want to provide them with a copy of this because we know what they're going to do with it. Can we withhold that because we think they have an ulterior motive for it? And the answer is no. You have to, any record that's open for inspection, you have to make it available. We are protected from any claim. We, being the association, is protected from any claim from a party that feels like that record was used against them. We just, hey, look, we had to provide it, and we're not responsible for what that person does with it. We're not responsible for overseeing them. So that's what there is. If you want to call it statutory protection, or whatever the case may be, you'd have to point back to that if somebody was mad at you for authorizing access to a document that maybe embarrassed them or whatever the case may be. All right, so records maintenance, a condo association must permanently maintain, and for HOAs it's 7 years, the following documents. It's the copies of the plans, permits, warranties, and other items provided by the developer, copy of the recorded declaration, bylaws, articles, rules, and any amendments, the minute book and the accounting records. For HOAs, it's for 7 years. And then for at least 7 years, you have to maintain the current roster and the mailing addresses, voting certifications, current insurance policies, a current copy of the management agreement, including in the lease and any other contracts, any bills of sale or transfer for all property owned by the association, and then all of the written records related to the operation. That's the kicker. It's the last one here is, it's kind of a catch-all for any other written record regarding operation. Now, if an owner requests, though, I want a spreadsheet showing such and such, if they're requesting a document that the association doesn't maintain, you're not required to create a document in response to a request access to the official records. These are just records that you have to maintain and provide access to. It's not that you have to create something that's not otherwise required to be maintained or provided by the association. So I think that's a key distinction there. Again, for condos, and really, I think I have this in the legislative update side, but for HOAs too, you have to maintain the ballots, the sign-in sheets, and the voting proxies for 1 year from the date of the election. So you don't have to maintain those for 7 years. It's just 1 year. All of the written records is applicable. All the rental records is applicable. For condos, you have a current question and answer sheet that's required to be updated yearly. You have to maintain that as an official record. Copy of the inspection report is provided for in the statute. And then as of July of 2018, the association must keep electronic records related to voting. Interesting that they don't have that actually in the HOA statute. I would still say to maintain that, though. I'm not going to read through all of these, but if you're a condominium that's 150 units or more, As of January of 2019, you should have been maintaining now a website that has access to the following documents on here that are official records. So again, only for condo units. If you're in here, a condo of 150 units or more, does this apply to you? But it has been updated to specify as to which documents need to be maintained on the website. Records that aren't available. So while they might be in official records that are accessible to members, there might be official record, these are records that aren't accessible to members. Any record that's protected by the attorney-client privilege, typically that's related to proposed or pending litigation or any type of work product privilege. But again, there can be instances where an attorney letter, if it's just a general opinion on something that doesn't involve litigation, might be open for inspection by the members. Information obtained in connection with the sale or the transfer of unit or property, that's also not a record of, so if there's like a background check or a credit report or something like that. Any personnel records, again, there's a distinction as what's considered to be a personnel record. Any medical records. This comes up, especially what we're finding is like from an FHA standpoint or an ADA standpoint, like from an official records inspection process through the official records inspection process for any type of an emotional support animal or reasonable accommodation request. The association is obtaining medical records because there might be a statement from a healthcare provider that so-and-so has a disability and that they're required to have this accommodation. That may be a medical record that needs to be kept separate from the records that are otherwise available for inspection by the members. Other records that aren't accessible, any electronic security passwords that the association may have, any software and operating system access information, any other identifying information like social security numbers, driver's license numbers, credit card numbers, and so on. All this kind of identifying information that owners have not chosen to disclose are not open for inspection. Owners can consent in writing to allow the disclosure of their protected information, if they want to have it in a newsletter or something like that. Contact information which requires no written consent for disclosure includes the name, the owner, the unit number, the mailing address, and the property address, and any email or fax that's been provided to fulfill the notice requirements. But again, the owner has to opt in to provide that. For condos and HOAs, the statutes will clarify that all telephone numbers may be included in a directory, although an owner may choose to not have their numbers listed, in other words, an opt-out. It's also revised to allow an owner to consent to the disclosure of additional contact information by way of opting in. The biggest thing with emails that you should know is that emails can only be used and are open is if that member specifically opts in to allow that to be disclosed and to receive electronic communications for official notices. If you happen to have an email address, that's not something that you can either use for electronic notice without their consent or to provide it to somebody else as part of an official record inspection. All right, so the inspection process, the records are open to inspection by any member or authorized representatives at all reasonable times. Association must respond to the record inspection request within 10 business days. It used to be 5 business days for condos. So it's 10 business days. You have to really make them available for inspection. Typically what happens is somebody will write a letter saying, I request access to the official records, and they might identify which ones they're looking for. So if you want to, you can kind of pinpoint down and make those available for them to inspect. But you just have to make those available within 10 business days of receiving of the written request. There was a question of whether or not, what if it's an emailed request? There's one arbitration decision where the manager confirmed receipt, but then later said that, well, it wasn't in writing, therefore the clock didn't start to run. The arbitrator said, well, you didn't refute, you showed that you received it, therefore the clock should start running when it was shown you received it. So is the lesson that you should never confirm receipt? I don't know that is. I would say the lesson is probably just to be conservative with it. And if they've emailed you before that same email address, it would be tough to say that even if you didn't confirm receipt that you didn't get it on a certain date and time. What you might want to do is that, if it was emailed at 3:30 or 4 or towards the end of the day, that you might wait until the next day to confirm receipt, because then the clock starts running from that date, for example. But I would say be more conservative. Don't take a hardline stance of saying, yeah, I got it by email, but I'm going to wait for it to be sent by certified mail, return receipt requested. You could be found to be in trouble if they don't send it that way, but you're otherwise found to have received it. So again, there's some teeth with this, because if you don't make them available within the 10 business days, the association or the owner can seek damages in the amount of $50 per day up to $500. unless, or if they can prove a higher amount of damages, if they can show that they were actually harmed and they can prove it. That's why there's some teeth associated with this, that you need to make the records available for inspection within that 10 business days. The association can comply with the inspection requirement by having the records available on the condominium or the association property, or making the records available electronically, whether it's through like a computer in an office or through the website. And the association is not responsible for the use or misuse of the information that's provided pursuant to the compliance requirements here. Also, as part of the records inspection process, if somebody sends you something saying, I want copies of the following documents, you're not required to drop what you're doing and find those, make copies and send them to them. What I would recommend doing is saying, hey, it looks like you'd like to inspect the records. Here's when you can come to our office to inspect them, or they're available on the website. You're free to find them there. But if you don't have them on a website, you can just say, looks like you're seeking to inspect them. Feel free to come by our office. You're not required, especially if it's a lengthy request, you're not required to go through and pick out and find everything for them. What a lot of times you just do is put the boxes on the table and let them go through it and look for it. You're not responsible to spend that time as a manager or as a board member to go through it. You can charge for cost of copying, reasonable cost. Don't try to, charge them $1 a page. I think it's like 15 to 25 cents or whatever it is, a reasonable copying cost, or if you have to take it offsite. If you're in an HOA and it takes more than 30 minutes to, I believe it's to obtain the records and make them available, that you can charge up to $20 an hour. But you cannot charge for the cost of sitting there with them or overseeing the inspection process. That's not a cost that can be passed on to the requesting party. All right. I don't think we have any questions on the official records. So then for the last part here, what I'm going to go through is just some of the different legal updates that we had from this year that kind of address what we're talking about. I wanted to highlight them specifically. So Senate Bill 630 was the big condo and HOA bill that was passed for community associations. Emergency powers were changed. So everybody understands with COVID that with everything, especially shutting down last year, as we're kind of understanding it, that we all look to the emergency powers in the respective property association acts that we have, the Condo Act, the HO Act, and so on. And there are emergency powers there, but they really dealt more with the inability to use the property or to meet safely in physical property. It didn't necessarily address having virtual meetings because it wasn't safe to be in person, or not using the common areas and amenities not because they were damaged in any way, because we don't want people being around each other, right? So they did clarify to say that in the case of a pandemic, the emergency powers also apply. So there's some expansion of those powers too, in terms of conducting board meetings, committee meetings, membership meetings, and elections via electronic or video communication. That was a big thing. I've been comfortable having a completely virtual board or committee meeting now, because it's not a member vote, it's a board vote, and board members have always been able to attend those meetings virtually anyway. But this specifically says that you can do it in the case of an emergency. So they're still a little bit open-ended if we're not in the case of an emergency and you can't use these powers. Nothing in the existing act says without emergency powers that you can meet completely virtually. So there is some risk for doing it by not having a physical location. I felt mostly comfortable recommending it, that you can still have that. But for member meetings, though, without having an emergency situation that you can use these emergency powers, I've still been recommending having a physical location for it, because there's an argument of whether or not members can be present virtually or not, and be deemed present virtually versus a proxy or in person, and then being able to vote virtually. As a member, you have to have electronic voting, or you have to vote by proxy. So I still think there's a difference between virtual Zoom meetings for boards and for member meetings, but at least in the case of an emergency, if that does come back, if there's a state of emergency declared, that they've clarified it to allow that completely virtual for all of these type of meetings. Condos may consult with public health officials when determining whether any portions of the property aren't available for entry or occupancy. But they also said that you can't prohibit owners or guests in a condo or an HOA from entering the property during a state of emergency unless it's based upon a governmental order or determination or a public health directive from the CDC. So in other words, they're saying if you're going to close down the community, it needs to be based upon one of these type of entities. You can't make it up yourself, essentially. So they did clarify that in the statute. There are some other additional changes in the emergency powers, but we've kind of gotten through. I just want to give some highlights on it. So for condos, recall disputes, if there is a recall and there's an argument over whether or not it was properly done, you can file for arbitration with the DBPR, or you can go in front of a judge in the court right away. That's a big change. You can also seek pre-suit mediation instead of arbitration for disputes. Historically, for a condo, if you had a dispute, you'd always have to go to arbitration for it. Now you can choose whether or not you want to go to mediation for it. And then if mediation is not successful, go and file a lawsuit right away. So that's a big change. I think it's going to help lighten the load for the division and the arbitration section and kind of give an access to the courts earlier for condos than what they otherwise had. It talks about board or committee members participating remotely in meetings, including for quorum and voting purposes. Talked about that before. This is a change, I think, to help maybe with rising condo premiums. If an association's insurance policy does not provide for subrogation rights against unit owners, then an insurance policy issued to a unit owner may not provide subrogation rights against an association. So what happens is if the association doesn't have subrogation rights, but then an owner files a claim under their HO6 policy and they have subrogation rights against the association, what's happening is that policy might be paid out and then that carrier may subrogate against the association without the association otherwise being able to do the same thing in the other circumstance where the owner caused the problem. So this will kind of help level the playing field, will result in less claims being brought by carriers for homeowners against the association, which then help their premiums go down, just because less claims filed means less premium, or, less premiums having to be raised. For condos and HOAs, discriminatory provisions may be removed from the governing documents without a member vote. That's a big thing. Now, I think you still want to talk with legal counsel. You can't use this as kind of carte blanche to undertake amendments by board vote that aren't otherwise discriminatory, for example. So you want to make sure that you're excising those. I would say even before this, we were always stating that, hey, this is discriminatory. We can't really enforce this. Now at least allows you to completely remove it to avoid any issue over it, and you can clean it out of your documents, which is good. Also clarified that bids for work to be performed or materials or services must be maintained by the association for at least 1 year after receipt of the bid. That's a clarification as the official records part. It clarified that renters only have the right to inspect the association's declaration and bylaws. Why not the rules and regulations? I have no idea, but that's just what a renter's right is. You as an association, where I talked earlier about providing like information and a welcome package to renters, that I think that you could choose to provide that. It's just what a renter's statutory right is. Associations may not require an explanation or reason to inspect the official records. We've already told the associations that you're not allowed to request it, and maybe there was a case that involved this, but now it explicitly states in the statute that you can't hold up an official records inspection because an owner didn't tell you why they wanted it. You can't require an explanation. Associations can make records available through a mobile app in lieu of posting on the website and satisfy, the making the records available for inspection. And then I talked about the 8-year term limit applies for service beginning on July 2018 going forward for the term limits. The other thing for condos is that they raised the transfer fee from $100 to $150, and that the DBPR may further increase it for every 5 years based on the CPI. The thing, though, I just remind you, is that a transfer fee can only be charged by an association to a party if that association has approval powers over the sale or the lease of the unit. You can't charge a transfer fee just, hey, you're leasing your unit. We're not going to approve or deny it. We just need notice of it and we need a fee paid for it. That's not really a proper transfer fee under the Condo Act. So be mindful of when you are charging transfer fees and trying to pass that cost along. But they did at least increase the amount that you can charge if you're allowed to charge the transfer fee. For natural gas fuel vehicles, have the similar rights to electric vehicles in terms of the charging station. So I talked about that earlier, that's been updated to basically allow it where if a member does everything correctly, they can install it without otherwise needing a member vote as a material alteration that the board could approve it. So they expanded that beyond electric vehicle charging stations to also include natural gas fuel vehicle stations. And then it clarified, this is kind of a clarification, but that 14 days notice is required for all membership meetings if the bylaws do not specify a specific notice requirement. Most do, but if there was a gap there and there was nothing in there, this is now the statutory default notice, which is at least 14 days. The other thing for condos, and then I'm going to get to the HOA changes too. Conflict of interest provisions in 718, 112, 2P between the directors and officers and service providers have been removed. but you can still allege a conflict of interest between the director and officer and the provider under 718-3027. 718-112-2P used to say that you couldn't enter into, it would make it very difficult or make it impossible to enter into agreements between vendors and then where the director and officer had an interest in it. They've kind of loosened that a little bit, but you still have to make sure that you're disclosing your financial interest under 718-3027. There's a process for it. So it makes it a little bit easier for board members and officers that have an interest in a vendor to have that vendor hired by the association. But you still have to make sure you properly disclose it, follow all the requirements from a conflict of interest standpoint. It also clarified for condos and for HOAs that fines are due within 5 days of providing the notice. It used to be that it was 5 days from the date of the hearing, but they didn't provide the notice for at least 5 days. So then it was already past due. They clarified it's 5 days from the date of the notice when you send it out. All right, for HOAs, recall and election disputes may be filed for arbitration, kind of like with condos. You could go through the DBPR or court action. Associations may also remove discriminatory restrictions from the governing documents without a member vote. The last one was a big change. This came in a couple of years ago and we knew it was going to be a problem. And I think they realized that it was a pain that you used to, for the last couple of years, whenever the association sent out notification to the membership as required under 720-306, which is really for any type of a member meeting or a member notice, that the association would have to double check the property appraiser website. And if there was an additional address there that you didn't have on file, you'd also have to send it to that address. So it created an obligation, a burden on the association to double check mailing addresses, which I think proved to be a huge problem. They eliminated that to say, no, it's based upon the address on file that the owner provides. And if they don't update it, that's on them. So that's where it reverted back to that, which is good. All right, so for HOAs, they eliminated including rules and regulations as being considered a governing document, which is a defined term under the HOA Act. And the reason why that was, I don't think that they realized at the time, by including as a governing document, it then said that anytime you amended your rule and regulation, you would have to record it because any amendment to the governing documents had to be recorded to be effective. So associations, every time they updated the rules, had to amend it. Now they've eliminated rule and regulation as a governing document, which now means that if you update your rules, among other items, you don't have to record it if you don't want to. Election documents must be maintained for 1 year after the date of the election. That's similar now with the condos. It's kind of brought the HOAs in line with that. Associations with more than 100 members may provide an alternative notice of meeting by posting on the website or a mobile app. You must adopt a rule with procedures before implementing. Get with your management, get with your legal counsel before doing it, just to make sure that it's being done right. I don't think that the statute is worded the best, so we want to make sure that we're covering our bases. And so you don't have an improperly noticed meeting come back to bite the association letter. But I think what they're working towards is trying to have an alternative way to post notice rather than, only on the physical location that maybe not everybody sees, for example. So if you're thinking about doing that, just make sure that you're following the current version of the statute on it. Records regarding security access, if it's in a gated or guarded community, are not considered open for inspection by the membership. That was new this year. We actually gave an opinion. It was actually a client that we provided an opinion to that said, yes, if you have a security guard that's engaged by the association and they keep a security log, I think that's an official record that's regarding operation, and it's not one that you can keep back. That actually, the president for that association contacted the state senator that covers their area and said, hey, this is a problem for us. We think that this should be confidential. There's some private information here. And that state senator went to some lobbyists and other sponsors of bills that basically said, I had a constituent that requested this. Can we include it? They said, no problem. That's an easy fix. And then guess what? It was implemented. So I say that to say it's the power of reaching out to your representative and let them know they want to hear from their constituents. And if you have a requested statutory change, what you say means a lot more to them than people that are paid to lobby to them. I can tell you that. As much as good of a relationship as a lot of, your state representatives and senators have with lobbyists, they know that they're being paid to push a position by a lot of times special interest groups. But you being the constituent that you actually vote for them, they are going to listen to you a lot louder and they will take that much more seriously. So don't be hesitant to reach out to let them know what you think of certain legislation or if you think a change should be necessary, because it can be something just like this where it gets passed. And then the last thing on here that I have was it eliminates the requirement to maintain mandatory reserves established by the developer. I talked about that earlier. So that was another HOA change. This is a big change. Leasing restriction amendments adopted after July 1st do not apply to owners who do not vote for such amendments and only apply to future owners, except if you are having a 6-month minimum rental period. Let's say you don't have a minimum rental period, or even if you have a 1-month minimum rental period right now, if you vote to have a 6-month minimum, or if you vote to, prohibit owners from voting more than 3 times per year, that's an exception to this new change, which says that if you get the votes, that's going to pass and it's going to apply to everybody. But if you try to go from no rental restrictions to a 12-month minimum rental period, it only applies to those who vote in favor and then any future owners, which is really what is the case in the Condo Act. So this was a change that we've seen coming for a couple of years now for HOAs, but they did kind of soften it a bit to allow you to kind of, if you still want to prohibit, the vacation, the Airbnb rentals, by making a 6-month minimum rental period, that if you get the votes for it, it's going to pass and it's going to apply to everyone. But otherwise they are cracking down. So the way that I would see this applying is some communities try to put a rental cap in place that say that, hey, once 20% of the members are renting, then you can't have any more renters until somebody stops renting and then you get added to the list. That type of an amendment would arguably only be applicable to those who vote in favor of it and then any future owners, because it's a prohibition or restriction on the ability to rent. So if you're thinking about, if you're an HOA, if you're thinking about changing your rental restrictions and to make it, whether it's a rental cap or number of times you can rent or a minimum rental period, you need to make sure that you handle it the right way and know how it's going to be applicable depending on the type of change that you're effectuating. All right, a couple other bills that passed. House Bill 7, this is effective as of March 29th of this year. Basically what it is, it creates a 2-part process, a 2-tiered process to bring a claim for any damages related to COVID. And why this impacts community associations is because there was a lot of question before of, hey, can we be sued if somebody gets COVID and there's resulting damages and they sue the association because they think they got it at the pool. Well, first, I think that we'd have a good defense about whether or not we have the obligation to prevent the spread of a disease, but aside from that, even if that's the case, they have the obligation in the initial stage with pleading with particularity how they believe that they were damaged by it and what the actions were and what led to it. And they have to submit an affidavit from a Florida licensed physician that the defendant, which in this case could be the association or management company, caused the COVID-19. So you're having a doctor or a licensed physician attest to that, that it was caused by them, which I don't know how many are going to be wanting to put their name on that. And they also have to prove that the defendant did not make good faith efforts to substantially comply with controlling health standards. So for example, if the association kept the pool open, but they said, hey, we recommend that you follow CDC guidance, don't be within 6 feet of each other, you should mask up, whatever the case may be, I would say that that made good faith efforts to substantially comply with controlling health standards, for example. So in other words, this just made it much more difficult. It provides more protection if someone were ever to bring a claim against the association or for management for saying that whatever it was, their policies or they contracted it to the association property, be very difficult to proceed on that. Change from Senate Bill 56. We've talked about this before. It's really regarding collection processes. So if the association changes the method of delivery of invoices for assessments, the association must provide the owner with written notice of the change of the delivery method at least 30 days before issuance of the invoice, and the owner must affirmatively acknowledge the change in delivery method before it can be implemented. Association must provide the owner with a 30-day late notice before attorney's fees can be assessed to the account. So up until July of this year, you could send a late notice and then you can charge reasonable attorney's fees for collection. Now it says you have to give them a statutory 30-day notice of, hey, if you don't pay here, we've already, whether that's the letter that also applies interest, or if you've already applied late fees and interest and you say, here's the status of your account, here's the amounts that are owed, and you have to list those out per statute. If you don't pay within 30 days, you could have legal fees charged to your account. So that's a new 30-day notice that's required now. The other change was that for condos, that for an intent to lien letter, which is typically be the next letter sent after that 30-day notice, it used to be you have to give 30-day notice and then you could record a lien. Now it's 45-day notice, which is the same thing as for HOAs. So it's a 45-day notice and then you can record a claim of lien. Then it's another 45-day notice of the lien. and that you can foreclose on it. So it's instead of a 30-day notice lien, 30-day notice for condos, now it's 45-day notice lien, 45-day notice, which is the same thing for HOAs. All right, for Senate Bill 1966 for the DBPR, it replaces the term monetary obligation with assessment when it looks at the delinquency of a member wishing to run for the board. What this means is that if a candidate running for the board is current on their assessments, that they have a fine imposed against them. Previously, you could treat that fine if it reached, I believe, the $1,000 amount and was outstanding for 90 days. You could say that they were delinquent in a monetary obligation and therefore weren't eligible to run for the board. Now it can only be for assessment purposes, but this is only for condos. So, and I think the reasoning behind it was probably because fines can be more subjective maybe than missed assessments are. And so it could have been maybe used as a tool to keep people from running for the board by imposing some kind of a bogus fine and keeping them off the ballot. That would be my guess for it. The other thing is that for condos, you must provide the annual budget to the members no later than 14 days before the beginning of the fiscal year. There is kind of a penalty for not adopting the budget too. And also states that the previous year's budget rolls over if you don't adopt the budget before the end of the fiscal year. So there are some budget notice requirements, just trying to make sure that that's done at least 14 days prior to the beginning of the fiscal year. Just some more budgeting requirements. All right, and the last thing that impacts associations, property insurance. Talk about this. You have to bring a claim within 2 years, as opposed to 3, which is what it was before. It establishes a mandatory pre-suit notice for claims not brought by somebody that you've assigned your claim to. So if the association is bringing its claim, then this pre-suit notice requirement applies. You have to give at least 10 business days before filing suit. It does tell the statute of limitations. You must include what the alleged act and omissions, damages in dispute are, what the demand is, and then any reasonable and necessary attorney's fees incurred by the claimant are. And then the pre-suit notice is admissible as part of any subsequent lawsuit. What they're trying to do, though, is have a tighter time period for filing your claims and have a pre-suit notice requirement. They've also made it a little bit more difficult to get your attorney's fees as a party bringing the claim, that you basically have to show that you went through kind of a good faith effort to work with the carrier before filing a lawsuit. Because previously in Florida, if you recovered $1 more than what the carrier offered, you get all of your attorney's fees paid for. Now you have to recover over a certain amount to get your attorney's fees, which encourages more of a good faith effort, I guess, to work with the carriers before litigating claims. So just notice this: if you do have an insurable event that requires a claim, and if your carrier doesn't pay, then you have to go through this process. All right, so in summary, board members have the fiduciary obligation to set aside personal agenda and put the association first. You want to stay focused on the job at hand, be familiar with your governing documents, know your duties and perform them competently. Setting goals and establishing values for your board and your community, and then obtain necessary education, whether it's attending this. We teach through Vesta, obviously we have legal updates and other courses throughout the year. There's all kinds of materials out there for you to become better educated as board members. And I think by you attending this on a Friday morning for, 2.5 hours here, I applaud you for it. And I hope that you obtained a lot of information from me on this. But you're doing your part as a board member or a future board member. And so I thank you for doing that. And that's what I have for my presentation. I'm going to leave it on this page. Again, it's got my contact information. If we can be of any service for you, please reach out. And if you'd like a copy of the certificate or of the PowerPoint, please reach out to Brittany, and her email is right here. But let me see if I have any more questions. I don't see that we have any more questions here. So Lee, do you have anything else you wanted to add before we sign off here?
No, I just want to thank everybody for attending and taking time out of your, valuable schedules. I recognize you guys are all volunteers, and we appreciate all of you and all that you do. And Ed, of course, you did a great job as usual. Thank you very much. And everybody have a great day. Happy Friday.
Thank you.